no executive director.
I understand.
Deborah Blasco, accountant.
Annie Curtis, chief inspector.
Okay, that brings us to agenda item number 1, consideration and approval of the agenda and its posting. Has it been properly posted?
Yes, it has been posted in accordance with open meeting law.
Madam Chair, I'd like to make a motion to find that we don't have to make a motion if it's been properly agendized. Is that correct? There's no motion required?
No, all you need to do is approve the agenda or make modification for this meeting.
We're okay. Okay. That takes us to item number 2, consideration and approval of the board meeting minutes for December 7th, 2009. Do I have a motion?
Madam Chair, I'll make a motion that we approve the board meeting minutes for December 7th, 2009 with any corrections that will be provided to Deborah Blasco.
Wait a second. Motion made by Alex Leader and seconded by Deborah Jones. All those in favor? Aye. Any opposed?
Madam Chair, can I ask the board members, please speak up? The storm noise and cars are making it difficult to hear. So speak up, please. Thank you.
Do we want to just go right on in? Or yes, I'm gonna go ahead and do the statement. At this time, the board will begin its disciplinary hearings. I'm going to take a few minutes to describe the process. When you hear your case called, please step forward and take a seat at the table. The hearings are conducted just like a trial. We have a court reporter who will swear in all the witnesses. He will also take down everything that is said in the hearing. He can only take down one person at a time, so it is very important that only one person speak at a time. The state will go first and present its case. You will be given the opportunity to ask questions of the state's witnesses. After the state has completed its case, you will be given the opportunity to present your case. You may present documentary evidence, call a witness, or even testify on your own behalf. The board may also ask questions, and the board will deliberate and make a decision. Now, I would like to say, though, if I do not say your name right, don't hold that against me. So we will move on to our next agenda item.
We would like to do number 6, which is oral complaint hearing. That's the word Cosmetology versus Sarah.
Good idea.
I need all the witnesses to stand. Be sworn in.
Everybody who's going to testify, please stand and raise your right hand.
Translation, is it? Let me swear the translator first. This is Spanish. Do you solemnly swear or affirm that you will accurately translate from Spanish to English and English to Spanish to the best of your ability? And if you will state the oath as I administer it to her, Mr. Green, and if she would stand. Have her stand and raise her right hand. Do you solemnly swear or affirm that the testimony you are about to give before this commission to be the truth, the whole truth, and nothing but the truth?
Chairman John Gard for the respondent. Bar number 5961. Goodness, Board Chairman, I couldn't have said it better myself. I've gotten a complaint, and State Council graciously offered to provide discovery and documentation in the state's case for me to prepare for this hearing. Or to be sent out.
Do we need a motion?
I'd like to make a motion that we grant the Indian state offer.
Continuing to a date certain.
Continuing it to the June 2010 meeting, I believe it's June 26th.
My motion would be restated to continue this to June 2010.
I'll second that motion.
Madam Chair, just as a clarification, this is for Laura Acero, license number 25497.
I apologize, it's actually June 14th. If you want to update it, I apologize.
And that's the correct response?
Correct.
Do we have any discussion?
I don't need to modify the time statement that I said June.
Okay, motion made by Mr. Austin, and seconded by Ms. Rinaldi. No discussion? All those in favor?
Aye.
Any opposed?
Thank you.
We are also going to change to agenda item, next one will be number 17. Okay, for complaint hearing.
On August 7 of '09, indicating that Ms. Alarcon had used a fraudulent social security number to obtain her license.
And then what did you do?
I looked up her file. I sent the social security number to the Social Security Administration Special Agent Lance Kidwell, and I asked him to verify the number that Ms. Petch had included on her application for license.
And what did Mr. Kidwell respond?
He responded on August 17th of '09 that her number that was provided was an invalid social security number.
And so what would that mean?
Invalid meaning that the number doesn't exist in their system.
Where did you get the social security number that you put on that memo?
From the application that she originally provided to us for her license.
Thank you. I'm showing you what's been pre-marked as State's Exhibit 1. Do you recognize that document?
I do.
And what is that?
This is the document that I sent to Agent Kidwell requesting that he verify the number, and this is the response I received.
I'd ask that this memo be admitted as State's Exhibit 1. And I apologize, copies of the board members will be available.
So admitted.
Mr. Green, I'm now showing you what's been pre-marked as State's Exhibit 2. Do you recognize that document?
I do.
And what is that?
This is the application for licensure in Nevada submitted by Ms. Petch.
And is there a social security number in this application?
There is?
And is it the same number that you included on the memo that you sent to Mr. Kidwell?
Yes, it is.
Thank you. I'd ask that this be admitted as State's Exhibit 2.
So admitted.
Mr. Green, I'm now showing you what's been pre-marked as State's Exhibit 3. Do you recognize that?
Yes, I do.
And what is that?
These were the documents that I found in the file of Ms. Pesh.
And what is that a copy of?
One is a Nevada identification card, one is a copy of the Social Security card.
And is that the same Social Security number that you included on a memorandum sent to Mr. Kidwell?
It is.
I'd ask that this document be admitted as State's Exhibit 3. I have no further questions for Mr. Green at this time.
Discussion, not any questions for Mr. Green? Would you like to make a statement, or would you like to take a quick? You're fine? Is there any board members that have any questions?
Madam Chair, is this your social security number?
It's not an ITIN number. I think the number that I can do taxes with, but it's under my name, so that's why I did it. But it's my application.
And is there a distinction?
I'm sorry?
Is there a distinction between my question and her response?
EIN number as opposed to a social security for clarification.
Or tax
An
return.
EIN is an employer's identification number. Or employer's identification number. And social security, these two are not.
No, it's my understanding that an EIN number is a two-digit dash number. I think so. Yes, thank you.
So I just would ask you again, is this your social security number?
Any other questions?
Hold on. So you have any questions for the witness?
I think the board's answered all the questions I would have. Thank you.
I did. She did. So,
Okay. Say something. I just want to have a question. What disciplinary action will you take since this happened? What's the consequence of it?
we haven't got to that part yet. Can I say what an answer? You can visualize.
Well, throughout this whole time that I've had my license, I haven't worked with it. So that's basically what I want to do. Just, I guess I know it's going to get revoked, but it's fine. So that's why I had anything else to add.
You can do a voluntary surrender if you want to, which means that you give your license up voluntarily, and the board may approve that agreement. It's probably a little bit better than having it revoked as far as your file goes. It's up to you.
And what about if throughout this whole time my status here, my legal status in the U.S. is being processed? So I will get it.
Do you want, let's continue this hearing. Do you want to have a talk with her?
We can have a recess for about 2 minutes.
Yes, sure. 5 minutes?
Yeah.
Okay, we'll break. 5-minute break.
current license. What she's saying is she never got it in the mail. In other words, we processed it, she paid her fees back in June or July, and she's saying now that she never received it because I think she says she's not working really.
Do we have a way of knowing whether it was sent out?
We could check.
You could check in the computer to see the date sent to verify that.
I think you could still accept a surrender even if she didn't have the paper copy. If she signs something saying that it's lost, but she does agree to surrender it, and she does agree that she won't work anymore as a licensed cosmetologist. I don't know, do you have any previous?
I don't have it with me.
Oh, okay, well, you could bring that in as well, your old one, and hand that to them, and then sign and say you don't have the new one, but you won't work anymore. I think that'd be fine, and we can get some paperwork ready today for that, because we want it done as soon as possible. But based on your oral affirmation, just so you're clear, I'm going to ask her to ask you if you agree with what we're talking about. You won't be able to work anymore. It'll be effective immediately. Handing the paper back is just a formality so the board has it, but you will effectively be surrendering your license at this point.
Okay, do you understand that you're surrendering your license? Voluntarily?
Yes.
Okay. I guess then I need a motion to approve that.
Let's have a motion and then discussion.
Okay, so I'd like to make a motion to accept voluntary surrender.
I want to double check that the motion, does that need to include that no other disciplinary action? And then my second question is if she's passed the testing, once she does have a valid Social Security number, can her license then just be reissued? Or does she need to go through the process of testing?
She would need to reapply because she would be handing back her license and not have one. She would need to fill out an application. Depending on the time that goes by, it's up to the board whether or not they want her to retest. But certainly she would need to do a new application and all of that, and provide all her documentation that way. And then I think it might depend on the time frame. It's my understanding she took the test in 2006, so I don't know how much time the board wants to give her. But maybe if it's within a year or something, and that I don't know the policy, but I think that's up to the board. She could always ask the board to waive the test in her case as well. She can petition to come before you when she's ready. And then you can determine if too much time has gone by or not. So you don't have to make that decision.
Thank you.
Again, just for clarification, she cannot get her license without coming back before the same board.
She can apply through the board, the normal process. I was just saying to avoid the test, because currently when you apply, it's my understanding you apply and you take the test if you need to, and you pass the test and then you get your license. In this case, she took a test in 2006 and passed it, but she's now surrendering her license. So if she wants to come back, obviously she's going to have to fill out a new application. That's a requirement. Then it's up to either the board staff, and if they aren't able to make the decision, she could ask the board to allow her to be reinstated based on her 2006 scores. And so it's just going to depend, I think, on how much time goes by. And that's my thought, just in general. And Vince will speak.
Vince Jimno, Executive Director. Basically, if the testing is on file and we have records of it, it's not been a lot of years, the staff can make that determination whether it's appropriate to consider those scores. If it's 10 years or something, that's totally inappropriate. In this case, it would be, if it was within a reasonable time frame of a year or 18 months, the staff would make the determination that the scores are appropriate, they're within a time frame that is consistent with the training and what have you today. So that would be a non-problem for us. And the only issue she's really been accused of, or allegedly accused of, is the fact that she did not have the proper documentation when she obtained the license. So that is the issue. That's what you're determining today. So if she reapplied and she had the proper documentation, it would go right through.
Any more questions?
I have a question. So I guess based on what we're talking about here, in order for anybody that goes down this road, and we are dealing with this in the future, in this type of situation, we just kind of want to be clear on the steps that it takes to help us to make the proper decision on
the issue is here, in 2006 would be considered a current training process. The curriculum hasn't changed very, very little over those years, so the curriculum is identical. She did qualify under the current curriculum standards, so that's not a problem. If the curriculum standards were significantly changed, and a couple of the different services have been changed recently, then it would be an issue that we might want to discuss at the board level, whether we reissue the license or not. In this case, she's current in the training and was practicing. The only issue did not have the proper practication. So it's not a training issue on the table that we're talking about. So I think we're okay now, but if the board wants to set a policy of no more than 5 years, or 7 years, that's up to the board. We can bring that up with different discussions.
Agenda 7.
Mr. Jimno, do we not have a 4-year limit right now? And if that is correct, 4 years, would that start from the time 2006, or would that start from the time now?
The current law, the way it reads, is that from the expiration or the expiration of the license is when it starts the clock. And Ms. Annie Curtis might be able to clarify that, but as I recall, the clock starts at the expiration of the license.
So that would be 2 years.
Well, it would be 2. It would be my understanding that there would be 2 if she has a prior license.
What the law deals with is a retention of records for them to be able to reapply as a person that's already been licensed. After 4 years, it's considered a brand new application to start from scratch. But the time frame in this case, my perception would be that, and it's only my perception, is that the clock starts upon the surrender of the license.
At that point, it's no longer valid. It's as if if you want to analogize it, it's almost as if it expires today. She's handing it over.
That was my question. I didn't know if she obtained it or if that date started then or if it starts now. But anyway, is there any more discussion? Okay, let's bring this. We already have a motion. A vote, excuse me. All those in favor of accepting? Aye. Any opposed? No. Okay. Here.
Rosales?
I did.
And how did that happen?
We received an anonymous phone call on October 8th, 2009, indicating that Ms. Rosales had obtained her license with a false Social Security number.
And then what did you do?
I submitted a document to Social Security Administration, Agent Kidwell, on October 14th, requesting verification of the number that was provided.
And what was Mr. Kidwell's response?
His response on the same day, October 14th, was that the number provided by Ms. Rosales had no match in the database.
And what is that?
No match means the number is not existent. I'm not sorry, correction. No match means the number doesn't match her name.
Mr. Green, I'm showing you what's been pre-marked as State's Exhibit 1. Do you recognize that document?
I do.
And what is that?
This is the document that I sent to Agent Kidwell and that he returned to me.
Is that a true and correct copy of the document that you sent?
It is.
I'd ask that this be admitted as State's Exhibit 1. And Mr. Green, on that memo that you sent to Mr. Kidwell, is there a Social Security number on that?
It is.
And where did you get that Social Security number from?
I obtained that from the file of Ms. Rosales, where she had used that number on her original application for licensure.
Mr. Green, I'm showing you what's been pre-marked as State's Exhibit 4. Do you recognize that document?
Yes, I do.
And what is that?
This is the original application and a couple of renewal forms.
And is there a Social Security number included on those documents?
There is.
And is it the same as the number that you sent over to Special Agent Lance Kidwell?
Yes, it is.
And were these forms prepared by respondent?
Yes, they were.
I ask that these documents be admitted as State's Exhibit 4. Mr. Green, I'm showing you what's been pre-marked as State's Exhibit 5. Do you recognize that document?
I do.
And what is it?
This is a copy of a Social Security card obtained from Ms. Rosales' file.
And was that Social Security card provided by Ms. Rosales when she applied to be licensed?
I'm assuming that it was.
I'd ask that the Social Security card be admitted as State's, this copy be admitted as State's Exhibit 5. I have no further questions for Mr. Green.
Does Ms. Rosales have any questions for Mr. Green?
No, I don't have any questions before I ask maybe. I think you might say as well.
Do I need to wait on this?
I have no further questions for Mr. Green, so if she doesn't have questions, it's now, I think, the board's turn to ask Mr. Green questions, and then you'll get to speak.
Does the board have any questions for Mr. Green? Okay.
She said she wants to speak. She doesn't want me to translate for her language.
Okay. Okay, Ms. Rosales, you can speak.
Like I say, I want to apologize.
Could you speak up for us?
Yeah. I like to say, sorry, I apologize to you. I didn't mean to do this wrong thing what I did, but I I came to university as a model, and I'm just be here because I have a little child, and I just need a little extension. I am working on my saddle legal, and I just need an extension. I have a baby 5 months old right now. I cannot go to Mexico. I can't leave my baby here. I'm just disabled. I just need the extension for because I have to work.
You guys understand everything that she said, how she came to the university? As a model. Just, questions?
Is this your social security number?
I guess I will need a motion. I make a motion to find Ms. Rosales guilty of fraudulent social security and this application. Is there a second? I'll second that. Okay, to find Judith Rosales guilty of the alleged violation or the violation of 644.210, NRS 644.214, NRS 644.430B, and NRS 644.430. Correct? Motion made by Deborah Jones, seconded by Koki Booth.
No.
You make it.
Yeah, I just want to explain to make sure that she understands that legally we don't have leeway to extend because the law doesn't give us the authority because it's fraudulent. Remember, we don't have the, we're not allowed, I've done that order.
It's the way the law is
When
written.
laws are written, we don't have the authority to override how the law is. Because the license becomes invalid because the Social Security number was not correct.
I have a question.
She has a question.
Is this a possibility you would want to, are you working on getting your social security number?
Yes, yes.
Is this a possibility you want to surrender your license also until you've got that social security number?
I'm trying to explain her that we can't, let you guys cannot allow this.
Madam Chair.
Yeah, she said she will surrender license.
Madam Chair,
Can't.
should we have our Attorney General just discuss that, just as we've had before, to give her some ample information and answer any questions that she may have regarding that process of surrender?
Like to take a 5-minute break.
I just want to ask this, do they understand what, not only that we can revoke their license, but we can penalize them, fines, and they could pay for the cost of court proceedings?
That's what,
The complaint notice of hearing doesn't include that information, however, it is written in English. I'm not sure if all the documents, maybe you can explain that to them, that, well, to the people there, okay.
Perhaps, Madam Chair, perhaps if our Attorney General helps to explain the voluntary turnover of the license versus the fining structure, it might help make her decision easier.
Yes. 10 minutes. If I could we take a 10-minute recess? And maybe the board members could go into the break room and get all the signatures, everybody. Yeah, I was going to ask everybody. Okay, we're going to bring the meeting back to order at 10:22. I understand there's asked for a continuance to find an attorney to come back with her. And so I have no objection to that request, and that would mean that she would be rescheduled for the June 14th meeting.
Okay, since we do have a motion on the table, I need to ask that the two board members rescind their motions.
I rescind.
Everything. Okay, so then we'll go and need a motion to extend or to postpone.
Discussion on that?
That make a motion to discuss it.
Continue.
So I'd like to make a motion to grant continuance to the June board meeting. No.
My question, would she be allowed to still continue to work based on this continuance?
They would be, because without a formal hearing on the merits, their license is still active.
Any other discussion? Okay. All those in favor? Aye. Any opposed?
Nay.
Nay. Nay. Thank you, so nay.
So that's 4 to 3. So the ayes pass 4 to 3.
Nays pass away.
No.
Or nays.
One of the nays raise their hands. So motion fails.
So what do we do on this case? Do we continue with the,
I think you might want to obtain some legal advice before proceeding here.
I would be very concerned that this woman has asked to continue this matter because she wants to seek legal counsel. Any action by the board is, I would not advise you to do that. I think that if it comes on judicial review, any judge may look at that and it would then come back to you.
so do we need to take another, get another motion?
And I would concur, on behalf of the staff, my general principle is to always, if somebody asks for continuance, I always give them the first request. We do send the paperwork in advance, but things happen, they try to get counsel, who knows what happens before they get here. So as a courtesy, and I think out of fairness to everybody, I always do not object to the first continuance. And again, I would concur with my colleagues' advice that, especially when someone's saying they want to see an attorney, they do have a right to see an attorney. Obviously the board will pay, but they have a right to have an attorney represent them. And so if they're indicating they want to talk to an attorney before entering into a voluntary surrender or other agreement, I have no objection, and I would ask the board to approve the continuance request.
And I'm going to ask that there's not really a health risk or anything on that lines right now because she's not ever had violations against her.
Yeah, I don't believe there's any grounds for a summary suspension or anything like that.
Okay, then I guess we need to make a new motion.
I'll restate my motion to grant continuance to June board meeting.
Motion made by Austin,
And I'd like to second that.
seconded by Ms. Jones. Is there any discussion? All in favor? Aye. Aye. Any opposed? Motion carried.
I abstain.
Kim, you abstain? Okay.
Generally, you only abstain if
It's like protest vote.
Well, then that would be a nay. You vote nay if that's your vote. But to abstain means there's some reason why you cannot participate in this action.
so then it would be 5 to 2.
Okay, the motion's been granted for continuance.
You'll receive something in the mail, Mr. Grace, could you verify for me?
I was just going to say there was a probably correct answer, so you could ask her on the way out to update her record.
And she understands that.
Do I, and
after that, I'll object unless there's very good, strong cause for continuance later.
Okay. That brings us to item number 7. Nevada State Board of Cosmetology versus Guadalupe, case number C09-116. There's violation of the NRS 644.210, NRS 644.214, NRS 644.430B, and NRS 644.430K.
Ma'am, would you raise your hand? Do you solemnly swear or affirm the testimony you're about to give before this board to be the truth, the whole truth, and nothing but the truth?
Before we proceed, Mr. Lewis, I know I spoke prior to this hearing, and I just want to ensure that you wanted to proceed today. I was unclear. Yes. So she wants to proceed today? Okay, thank you.
She said for the extension.
Oh, she wants to have an extension? And she wants to get an attorney?
Yes.
Based on Ms. Carrillo's intention to get an attorney and her request for a continuance, I have no objection, and I would ask that this matter be continued to the June 14th meeting in Las Vegas.
Do we have a motion?
I make a motion to move a continuance to the June 14th meeting. For case number C09-116, Guadalupe Carrero.
I'd like to second that motion.
Motion made by Ms. Liu, seconded by Ms. Jones. Any discussion?
Madam Chair, clerk,
Maybe council or maybe explain consequences of why we granted
The continuance?
Yes, so just so board members are clear, so they don't feel uncomfortable with granting them, I know some people.
Yeah, the real reason is everyone has a constitutional right to come before the board, and they have a right to due process. And due process requires that if they ask for an attorney, we don't force them to go forward without one, within reason. And, you know, one continuance, I think, by any judge's standards, would be reasonable.
I understand that for American citizens. But does that right pertain to constitutional rights pertain to
Yes.
legal citizens?
Yes, everyone has a right.
Well, because they have been issued a license, and so they have a property interest in the license regardless of their citizenship. The board has given them a license. And so now, before we take it away or do anything to it, we have to have a hearing. They have to have an opportunity to be heard on the merits of the case before anything happens. And so part of an opportunity to be heard, a meaningful opportunity, is the right to an attorney after proceeding, if they want one. Obviously, not everybody chooses to have one. But in this case, she's asking for one before she proceeds. And so
On the advice of counsel or just in educating about the situation, they're allowed to keep working. They understand that if they come before us again, that we will ask for court proceeding charges, and they will be responsible to pay for all the fees.
Is that something that you do for everyone?
Yes.
Certainly. But
certainly,
generally,
yeah, and that's something that you can handle. When you have the hearing on the merits, normally what you do is you determine guilt or not. The second part is determining the penalty. And then the last part is determining costs. And that's what you're talking about.
Right.
but you can't get there and you can't discuss that without first having a hearing and finding guilt, which we've not done yet.
Okay, but not for me, but just so they understand.
I did try to explain to everybody here that those are things they could face at a hearing. You know, there could be a fine, there could be costs assessed against them for the interpreter's time,
of the amended complaints and the notice of hearings, we do advise them to consider their rights and consider having their attorney present. And so, are they not reading this well enough that they're coming before us to then ask for continuances? I mean, I'm just not quite sure how we can be a little more encouraging to bring all of us together and have them be more encouraged to be prepared.
I think there's several things possibly happening. The first one is that the notice is sent out 30 days prior. They may not get it right away. Attorneys are busy, they're busy. I believe, at least in some of these cases, they have tried to talk to attorneys and just haven't been successful in the time that they've had prior to today. The other issue potentially is this is all written in English, and I know for some of these respondents, English is not a language that they read or speak very well. And so it's possible they're not completely understanding everything in the complaint, unfortunately. And today they have the ability to have an interpreter help them understand better what these documents say. And so,
is there an opportunity then to upgrade the amended complaints and notice of hearing to minimize the number of continuances so we don't all get together to have to hear this same matter today and in the future?
Upgraded meaning like write it in Spanish?
Or, be a little clearer that...
Even if but the timing issue and the English issue aren't going to be really affected by clearer language.
And this is the standard language I use for all the complaints that I do for all of my clients. I don't know what I can do to make it clear, really.
I'd like to say something too, if I may, right here, is that they have not, they passed a test, they were given a license, and so I think to have the due process of having an attorney here to really make sure that they do have a social security number or they don't is really important. If they were out there harming the community, then I would feel totally different about this. But we did grant them a license without checking the social security number. So I think some of it falls back on us. That's my own personal feeling.
But at the same time, we don't have, we can't do that either. So
Right.
one thing is that we are obligated under the law to follow due process. Due process is what we're doing.
Okay, bring this to a vote. All those in favor? Aye. Any opposed? Motion carries. Ms. Carrillo, you've been granted a continuance, and I want to make sure that you understand that there will be no further continuances after that.
I want to explain the mistake. You understand? Yes, she understands.
She understand?
Yeah.
Okay. Is there anything else?
Yes.
Not in this case. The only thing I would ask is, Mr. Green, if you could double check Ms. Carrillo's address before she leaves, just to make sure we have the correct information. Also, her phone number would be nice to make sure we have a correct phone number just in case.
I did have another quick question. If they're not serviced properly without a correct address and phone, does that give another opportunity for continuance?
It can. However, they have an obligation to ensure that the board has the correct address. And so legal service is completed upon mailing to the address that they provided to the board. That's legal service. However, the Nevada Supreme Court and the United States Supreme Court have recognized that if we have other information, we should use that. So for example, a lot of these individuals have their home address and maybe there's a problem with that address, but we also know where they work. So if we send it to the home address and we have a problem, then we also try to send it to where they work as well. Because even though we've completed service, it's always better to give have changed. So I'm asking him to check, not really out of problems always, but just to double check that we have what we need, since they're here today.
That brings us on to item number 8, the Nevada State Board of Cosmetology versus Jose Rodriguez Chadias. Case number C09-117, alleged violation of the NRS 644.210, NRS 644.214, NRS 644.230B, and NRS 644.430A. Could you stand by these?
You solemnly swear or affirm the testimony you're about to give before the board to be the truth, the whole truth, and nothing but the truth.
Could you state your name and spell your last name?
Jose Rodriguez. Jose Rodriguez.
Madam Chair, during the recess, I spoke with Mr. Chides, and he indicated that prior to the hearing, he and two colleagues had attempted to obtain representation, were unsuccessful. He would like to continue trying to find an attorney, so he is asking for a continuance. And given that it's his first request, again, I have no objection.
That would be to the June 14th.
Yes.
Madam Chair, I'll make a motion to continue Jose Rodriguez Chades, number 27497, until the June 14th meeting.
Okay, hold on a second.
He just said that he wants to,
Voluntarily surrender.
voluntarily surrender.
Oh, okay.
He doesn't have it,
Okay.
but he will.
I'll retract my motion.
I apologize. That was one of the things we discussed, but not.
So we need a motion to,
Yeah, hold on, she's going to ask questions.
I would just like to present then our discussion regarding voluntary surrenders. I'm going to go ahead and say some things about what you're agreeing to, and then the board will ask you if you agree. Okay? Okay. So to do a voluntary surrender, we need to agree that the Social Security number you provided was not valid. Is that true? And therefore, we talked about that you can surrender your license. And what that means is you can't work anymore as a licensed cosmetologist after today. Today is, it's effective right now. And what you'll have to do is come back to the board office and give them your paper license. But it's effective right now the minute that you agree on the record. And we will send an order to you that tells that says that you've surrendered your license and the board has approved that voluntary surrender. Do you understand that?
Yes.
And what that means too is you won't have a license right now, but you can come back and reapply in the future if you have the correct paperwork.
Yeah.
And what that also means is it does count as discipline, so it will be in your file, but it's a voluntary surrender. There's no fine, there's no cost, and it's not a revocation or a suspension. So if you ever reapply, you don't have to mark that you were revoked because you weren't. Do you understand that?
Yeah, that's fine.
Okay, so you still have to tell people about it. I'm guessing any other state would ask about discipline, and I know Nevada asks, but it's not a revocation.
No, I come back from Mexico.
Okay,
Yeah.
okay. So, Madam Chair, I would ask that you just double check with Mr. Chides that he does want to surrender his license, and then I would ask that the board approves his voluntary surrender of his license. And I would like to verify his address, and we'll send him an order, and he should come back and surrender his license. Casey can't come back this afternoon, maybe if he could come tomorrow, say no later than tomorrow by 5 o'clock.
Mr. Rodriguez, you do understand that you are turning your license over voluntarily, and you will comply with everything that the Deputy Attorney General has said.
Yeah.
So he'll give a paper copy tomorrow by 5. Is that okay?
Is that a yes?
Yeah.
He needs to say yes.
Sí.
Oh, yes. You have to say yes.
Okay, do I have a motion?
I make the motion to suspend,
Accept.
accept the voluntary surrender of Jose Rodriguez's license. He will turn it into the office in 48 hours.
Okay, motion made by Ms. Booth, seconded by Mr. Austin. Any discussion? All those in favor?
Aye.
Any opposed? Motion carries. Okay, and Mr. Rodriguez, you do understand, go with that.
Well, you can't work anymore, and it's effective right now.
Okay, that's it, thank you.
Thank you. God bless you, everybody.
Let's see, item number 9, Nevada State Board of Cosmetology versus Juana Guzman Cruz. Case number C09-018, alleged violation of NRS 644.210, NRS 644.214, NRS 644.430B, and NRS 644.430A.
Do you solemnly swear or affirm the testimony you're about to give before this board to be the truth, the whole truth, and nothing but the truth?
You want to state your name?
Juana Guzman. Has Ms. Cruz decided how she'd like to proceed today? She wants to get an extension so she can make someone to represent.
Based on Ms. Cruz's intention to obtain an attorney and her request for an extension, I'd ask that her hearing be continued for the June 14th, 2010 meeting in Las Vegas. It's my understanding that prior to the hearing, Ms. Cruz did attempt to obtain an attorney, and she spoke to at least one and would like to find someone to represent her.
Do I have a motion?
I'll make a motion to, that we grant a continuance to the June 14th, 2010 board meeting. So, those can continue to the council.
Second.
Motion made by Mr. Austin and seconded by Ms. Booth. Any discussion? All those in favor? Aye. Any opposed? Okay. We've granted your continuance, and I'd like to advise you that there will not be a further continuance after the June 14th. Do you understand?
Not for the response.
Yeah. So she's done.
She's okay.
Thank you.
Did we verify her mailing address before she leaves, please?
Do we know the establishments of these workers? I mean, are they all coming out of the And is that relevant information?
No, because if I look at the 10 mine fraudulent, and I solution rent, they have no legal right to check my social security number.
So there's no establishment citation that's given for hiring somebody?
No, the establishment would have to be assumed to be hiring competent and licensed staff because we issue the license. Well, in our determination of finding fraudulent documents within the file, that does not affect the establishment whatsoever. The pigeons of there. Anyway, there is no nexus between the individual licensee and the establishment which they work in. There's some proven conspiracy of some type. We do not establish that.
And so it's understood that we're not, I mean, of the 10 that we've heard, there's not one established. And even if it were, it would be irrelevant.
That's correct.
Thank you.
Okay, that takes us on to item number 10. Nevada State Board of Cosmetology versus Sylvia Soria, case number C09-120, alleged violation of NRS 644.210, NRS 644.214, NRS 644.30B, and NRS 644.430A.
You solemnly swear or affirm the testimony you're about to give before this board to be the truth, the whole truth, and nothing but the truth.
Is she a witness?
She was asking for her daughter to interpret, but I said it's better to have the court interpreter.
Right.
So, do you want her to sit back there?
Yes.
Could you state your name, please?
Sylvia Soria.
Okay.
Ms. Soria, have you decided how you'd like to proceed today?
She wants to ask for an extension.
Okay. Again, it's my understanding that Ms. Soria, along with the previous respondent, did attempt to get legal counsel prior today, and she would like to continue to try to get an attorney to come back with her for the June 14th meeting. Based on her first request for a continuance to get an attorney, I have no objection. I've asked the board to approve the continuance to the June 14th meeting, which is the next Las Vegas meeting.
I'll make a motion that Billy Frank give us continuance for Ms. Soria to the June 14th, 2010 board meeting, so she has a chance to obtain counsel.
I'll second. Motion made by Mr. Austin, seconded by Ms. Jones. Any discussion? All those in favor? Aye.
And so will this be a 2-day meeting?
It'll be the same meeting, repeated.
And there is really no avenue to minimize the number of continuance requests?
Not really. I mean, sometimes we know prior to the meeting, for some of my other agencies that I work with, frequently people will ask prior to the meeting, and so we can alert the board ahead of time that maybe the meeting will be shorter than we anticipated or something like that. But they really have the right to ask for a continuance.
And they ask that continuance formally as opposed to us asking if they want that prior to?
Either way, I mean, I think sometimes when you come before the board, you realize that it's not what you thought it would be, and you feel like you should have an attorney with you. And so sometimes the day of, I think people realize maybe they should consider that, and maybe they hadn't really thought of it prior. And so I'm not sure how to minimize that. I think they still have the same right. And then there are people who and we do have coming up, 2 cases where we had a written request approximately, I think, 2 weeks ago for a continuance. So that person received a notice and said, I don't, and they did send a written request in. So I think you have both kinds of requests, and I don't really know that there's anything we can do about it. And I think as we continue continue, maybe we'll see, more of that, but at the same time, it'll even itself out because we'll be hearing cases next time, maybe there'll be continuances and it just sort of works itself out.
Is there a possibility that between now and the June 14th meeting that some will voluntarily surrender?
I think there is that possibility. We also have 4 voluntary surrenders today, so I think certainly that can happen.
Madam President, it's really incumbent upon the board members to recognize that justice is very slow when due process is installed into the system. This protects everyone's rights. It protects your case by making sure you cross all the T's and dot all the I's, as well as it protects the rights of the individual to be sure they're properly represented. Patience in this case is really what you have to consider. That's why the courtroom itself takes so long to resolve cases, because we're protecting against anyone's rights from being violated, and also that we proceed in a manner that is totally defensible in the courts. So you just need to understand this. It's always going to be like this, but we can attempt to speed it up as best we can by getting better advice and learning new tricks to make it understandable what the ultimate situation will be for each of the people involved. But I think patience in this is absolutely required.
Thank you.
Mr. Ria, the board has approved for you to have a continuance, and I would like to advise you that there will be no continuances after June 14th. Okay? Yes. Thank you.
Number 11 and 12. 11 is Nevada State Board of Cosmetology versus Maria Leticia Romero. And number 12 is Nevada State Board of Cosmetology versus Letty Salon de Luisa Maria L. Romero, owner. The board has received written requests from Ms. Romero for a continuance in both cases. She would like to speak to an attorney prior to having a hearing. And I have prepared something for your signature. I'm not sure if you received it. So I would ask that we approve that continuance and send that to Ms. Romero. I have spoken to her on the phone and told her that we would be approving that because board staff had no objection and we did speak to you about it. So we'd ask that be continued to June 14, 2010.
Do we need to do each one separately?
No, I think you can do it together with one written request.
So, Madam Chair, I'll make a motion to authorize the board chair to sign the notice of continuance for Letty Salon de Bellezia, Maria L. Romero, owner, license S10753, and individually Maria Leticia Romero, license 24290.
I'll second that.
Motion made by Mr. Rader, second by Ms. Booth. Any discussion? All those in favor? Aye. Any opposed? That takes us to item number 13, Nevada State Board of Cosmetology versus Ivaco. Gonzalez Chavez, case number C09-109, alleged violation NRS 64.20, NRS 64.214, NRS 64.430B, and NRS 644.430A. Is Mr. Chavez
meeting law service requirements because he executed the documents after the 30-day notice. And the second document I have for the board's consideration is the actual voluntary surrender agreement as well. It has been signed by Ms. Aracel Gonzalez Chavez, and also I have approved it as to form, as has Ms. Chavez's attorney. So what we would need for the agreement to be complete is the board to approve it, a signature by the board chair and executive director. In the agreement, she acknowledges that the Social Security number was fraudulent and voluntarily surrenders her license and agrees not to practice any further.
I'd like to make a motion then, Madam Chair, that we authorize the board chair to sign the amended voluntary surrender in lieu of other disciplinary actions regarding Aracel Gonzalez Chavez, license 28147.
Actually, it might be simpler to disapprove the agreement, just so that.
To approve
Yes.
and sign the
Yes.
amended voluntary surrender agreement.
I second.
Motion made by Mr. Reader, seconded by Ms. Haziger. Any discussion? All those in favor?
Aye.
Any opposed? Motion carries. Okay. Now,
Are all these the same?
Yes.
Same documents?
now, item number 14 is the same.
Yes. Inez Gonzalez Chavez. Again, Ms. Chavez was represented by counsel. We have drafted a voluntary surrender agreement in lieu of other disciplinary action. The agreement has been signed by Ms. Inez Gonzalez Chavez and also approved as to form by myself and Ms. Chavez's attorney, Mary Perry. I also have a waiver of open meeting law service requirements in this case because, again, we executed the agreement after the requirement. I'd ask that the board approve the agreement, and all we need to fully complete it is a signature from the chair and from Mr. Jimno.
I have a motion. Second.
I'll make a motion that we accept the voluntary surrender.
Second.
Second.
Okay, motion made by Mr. Austin, seconded by Ms. Haziger. Any discussion? All those in favor? Aye. Any opposed? Motion carries. Item number 15.
Yes.
Nevada State Board of Cosmetology versus Rufina Gonzalez Chavez. Case number C09-112, alleged violation of NRS 644.210, NRS 644.214, NRS 644.430B, and NRS 644.430K.
Again, we have entered into a voluntary surrender in lieu of other disciplinary action in this case. Ms. Chavez has admitted to providing an invalid Social Security number, and we have a voluntary surrender agreement that I have approved as to form, as has her attorney. The agreement is also signed by Ms. Rufina Gonzalez, and we've asked that the board approve the agreement, and all we need to finalize the agreement will be a signature from the chair and from Mr. Jimno. Again, we have a waiver of open meeting law service requirements in that case.
Motion.
I make a motion that we accept the voluntary surrender of license for Ms. Rufina Gonzalez.
Have a second.
I'll second.
Okay. Motion made by member Mr. Austin and seconded by Ms. Booth. Any questions?
Ms. Bradley, I just want to double check that when I'm reading page 2, that in that second paragraph from the bottom, that the respondent is also waiving their rights to appeal this amended voluntary surrender?
Yes, that is one of the things that a voluntary surrender does, is there's no right to appeal it to the district court. They immediately stop working, they give the license over, and so the matter is concluded as of today.
And so there's no difference in this voluntary amended surrender and any of the other ones that we...
Okay.
The reason it's amended is I noticed there were, well, actually Ms. Glasgow noticed that there were a couple statutory citations in error in the previous agreement, and I had already sent it to the other attorney, and so to be clear, I sent them an amended voluntary surrender with the correct citations, just so that we had record of what I had done. So I just goofed on the first one.
Take a vote. All those in favor? Aye. Any opposed? Motion carries.
Thank you, Ms. Glasgow.
Okay, item number 16. Nevada State Board of Cosmetology versus Inez Beauty Salon. Inez Gonzalez Chavez, owner. Case number C09-121, alleged violation of NRS 644.3401, NRS 644.430B, and NRS 644.430A.
It's my understanding in this case that the ownership of the salon has changed. They have come into the office and completed the paperwork to do that, so that the owner of the salon no longer has an invalid Social Security number. And Mr. Green has evidence about this if you'd like me to call him.
Does that mean that we have a match from Mr. Kidwell?
Have we checked the new Social Security number?
Well, it's the same. Inez Gonzalez Chavez was the previous owner of Inez Beauty Salon. So the surrender that you just accepted was one of the owners, was the owner of this salon.
But now there's a new owner.
Now there's a new owner.
Yes.
And do we have
As
a
of
match?
February 12th, Valvanero Aguiar purchased the salon.
We're not allowed, this Vince Jim, no, executive director, we're not allowed to check that. There's no system for us to check Social Security numbers in advance, only if we open a criminal investigation.
Thank you.
And based on the fact that the ownership has changed, I would withdraw the complaint in this case.
Was the ownership license surrendered?
Well, the owner surrendered her personal license, and that was a previous case you just
What about her
approved.
establishment license?
Well, she didn't have to surrender it because now there's a new owner, and so if there's not an issue, it was sold, and so the establishment can stay open, but she's just no longer having an invalid license or Social Security number being the owner.
Need a motion to...
I would,
withdrawn it?
yeah, I would like to withdraw the complaint, and I guess the board should approve the withdrawal.
I'd like to make a motion that we withdraw the complaint of item, case number C09-121, alleged violation of NRS 644.0.1, NRS 644.430B, and NRS 644.430LK.
Second.
Motion made by Mr. Austin, seconded by Ms. Booth. Any discussion?
I have one. Feel free, Ms. Jones.
Oh, I was concerned about the ownership license and why that wasn't surrendered.
Can I, do that? Because it doesn't exist anymore. Somebody else bought it and they applied and got a whole new license for
I
that.
see. So it's different.
It's an whole different person.
Oh, thank you.
Is that correct?
She no longer has an ownership interest.
So
So
that's
there's nothing to
one of the reasons they're saying this, whenever you apply, you don't check Social Security unless it's a blank file. In this case, it's a new person, so there's no reason for us to hear, but they don't even know it. They don't even know it anymore anyway. The license doesn't exist any longer.
And then I just had a quick question. So we're no longer looking at a license 10595. The new establishment has a new number.
That's correct.
Mr. Vogt, all in favor?
Aye.
Any opposed? Motion carries. Okay. Spa and Salon Professionals, case number C09-79, alleged violation of NRS 644.395, NRS 644.4001, NAC 644.085.1, NAC 644.085.2, NAC 644.085.4, and NAC 644.325.3.
Madam Chair, before you proceed in this case, I would ask for a brief recess to confer with my witness.
Okay, we'll take a 10-minute recess.
I've only had to help her a couple of times. If her bruise, hers are bruised.
My shins off from him kicking me under the table. Check.
I just noticed it was.
Oh my God, I am just like, let me tell you, I am the biggest kid.
We're sharing here, so.
It was funny. You'll see on the bill.
Order at 11:25. Do you want me to repeat the item number?
Yes, please.
Item number 18. Nevada State Board of Cosmetology versus Destination Academy for Spa and Salon Professionals. Case number C09-79, alleged violation of NRS 644.395, NRS 644.400.1, NAC 644.085.1, NAC 644.085.2, NAC 644.085.4, and NAC 644.325.3.
Madam Chairman, I would like to recuse myself of making any comments on this, as my niece is an instructor at Destination.
But would that affect you from making a decision on this case, Linda, just because you're aware of that relationship? Are you still able to make an unbiased decision?
We're also friends, my husband and I were friends with Gary.
And are you still able to make an unbiased decision?
She said she has a personal relationship with the respondent.
Yes, I would rather just
That would be
not
appropriate.
comment on it.
I would call Ms. Pamela Steele as a witness in this case.
If both of you would stand there and raise your right hands. Do you and each of you solemnly swear or affirm the testimony you will give before the board be the truth, the whole truth, and nothing but the truth?
Would you please state your names?
Pamela Steele, is S-T-E-E-L,
Who is your employer, Ms. Steele?
State Board of Cosmetology.
And what is your job title?
Inspector.
As an inspector for the State Board of Cosmetology, what are your duties?
I inspect salons in schools and investigating complaints.
In the course of your duties as an inspector for the State Board of Cosmetology, did you become aware of a licensee named Destination Salon and Spa?
Yes.
And how did that happen?
I went out on an inspection, while I was in training actually, went out on inspection of the location.
The record should reflect that the board has been given the exhibits in this case. Mr. Wasak indicated he had no objection to them being did it all at once rather than individually. So the board is in possession of exhibits numbered 1 through 11. And we'll go through them one by one when we go through their testimony. Okay, Ms. Steele, let's go through the 8 inspections
inspections that relate to the complaint filed in this case at Destination Academy, starting with the first inspection on July 13, 2006. What did the board's staff present observe on that day?
The two inspectors were Susan Padilla and Pamela Fitzgerald, and they cited violations of NRS 644395. There was only one instructor present, and at that time we spoke to them on that.
Is there a report in the licensee file regarding that inspection?
Yes.
And is this report maintained in the licensee's file in the ordinary course of business and as part of the State Board of Cosmetology's business records?
Yes.
Thank you. Now let's talk about the October 4th, 2007 inspection. What can you tell us about that inspection?
It's like 10-4.
10-4, yes.
That would be inspectors on that one was Susan Padilla and Pamela Fitzgerald. And the violation cited on that was NRS 644.395. That would be the second time for that one. And that's one licensed instructor on duty. And NAC 644.085.2. There were 6 hair dryers, and the laws state they need 10. And NAC 644.085.4. There are 4 manicure tables, and the law states they need 10. And NAC 644.313.2, there were trash receptacles that needed lids. There are 10 of them without lids.
Is there a report in the licensee's file regarding this inspection?
Yes.
And is this report maintained in the licensee's file in the ordinary course of business and as part of the State Board's business records?
Yes.
For the board, can you tell us what exhibit talks about those last 2 inspections? What number they should have in looking at?
The last 2 inspections, you mean you want the...
Yeah, what number is that in the packet we gave them?
Well, they're actually dated, the 713, which we don't have them listed as an exhibit number.
Okay, so they can look at the dates in the back to
Yes,
find those. Okay, so we were talking about the July 13, 2006, which is tab, and we were talking about October 4th, 2007, which is tab. Okay, thank you. Okay, now let's talk about the March 5th, 2008 inspection. What can you tell us about that inspection?
That was actually my first inspection out there. I went with Inspector Green, Jeffrey Green, and Pamela Fitzgerald. And we cited NAC 644.085.4. And it's the second time we cited the 9 manicure tables and we needed 10. And NAC 644.085.12, they needed a time clock there. And NRS 644.395, there was only one Cosmo instructor on duty.
And were some of these violations repeated violations?
Yes.
And what violation was that?
That was the NAC 644.085.4, the 9 manicure tables, and they needed 10.
And what about NRS 644.395?
That was actually the third time we had that.
Is there a report in the licensee's file regarding this inspection?
Yes.
Is this report maintained in the licensee's file in the ordinary course of business and as part of the State Board's business records?
Yes.
Now let's talk about the June 13, 2010 inspection. What can you tell us about that inspection?
We received an anonymous complaint alleging improper petty spa bowls, and students had to sit on the ground to perform the pedicures, and that Amy Waysack, which is one of the owners, was registered as a student but not attending any classes.
And so what did the board staff present observe on that day?
The inspector on that was Inspector Jeff Green, and he cited NAC 644.085.1. The petty spot drainage utilizes one of the shampoo bowls out of the 10 that are necessary at all times. One of them had a pump to drain the shampoo, the petty bowls in that, so you couldn't use it as a shampoo bowl at that time. And he also stated NRS 644.395, and that was one Cosmo instructor on duty.
Which had been a previous violation?
Yes.
report maintained in the licensee's file for ordinary course of business and as part of the State Board of Cosmetology business records?
Yes.
Now let's talk about the July 18, 2010 inspection. What can you tell us about that?
We responded to...
Oh, 2009, excuse me, I apologize. I apologize.
We responded to numerous complaints and the number of instructors on duty, and I was the inspector that responded to that. And I cited NRS 644.395, and there was only one Cosmo instructor. And I advised Mr. Waysack that the instructor must remain in the school walls. They have a salon that's attached, and he wasn't in the salon or in the school area. He was going to be the second instructor. And I cited also NAC 644.085.4, and he had 6 manicure tables, and he needed 10. And NAC 644.085.2, there were 6 hair dryers, and he needed 10. And NAC 644.085.1, there were 7 shampoo bowls with chairs, and one had a pump in it to drain the petty spots, and there weren't chairs in the other.
Did you talk to Mr. Waysack on that day?
Yes, I discussed the problems of the continuous violations and the insufficient instructors on the premise. And we discussed the shampoo bowls and that the law states they must all be available at any time. So if one's down, you have to have it available. You have to fix it.
And were these repeated violations?
Yes, they were.
Did you take photographs at the inspection on that day?
Yes, I did.
I know you're looking at what's been marked as number 6. Are those photos the photos that you took on July 18, 2009?
Number 8 is
Okay, number 8. So number 8 are the photos you took on July 18, 2009.
yes.
And you recognize these photos?
Yes.
And what do they depict?
The first one I have is where Gary was saying that he could stage the first manicure table with 2 manicure chairs so they could count as 2 stations instead of 1. And I told him that staging it, that you could stage it, didn't count for it. Right, with the picture of 1 chair on each side, it's only 1 table. And the second one is the shampoo bowls that do not have chairs to them, so they're not accessible to use as shampoo chairs. The next picture is just showing that's just showing that the ones that did work that we have available. And the other one is the pump that he was using to empty the petty spa bowls is in the shampoo bowl, one of the shampoo bowls.
Did you take those photographs?
Yes.
And are these photos a clear and accurate depiction of the school as you observed it on July 18, 2009?
Yes.
Okay, now let's talk about the inspection on August 12, 2009.
Yes.
What can you tell us about that inspection?
We had numerous complaints again, reference the number of instructors. I was the responding inspector for that one, and cited NEC 644.085.1. There were 5 shampoo bowls available. There were 4 stainless chairs, and 1 sink still had the pump in the sink. Then NEC 644.085.4. There were 6 manicure tables and 10 were needed. And NAC 644.085.2, there were 6 hair dryers, 10 were needed. And NRS 644.395, he was using an esthetician instructor for the night classes, which left only 1 cosmetologist instructor on duty at night.
And did you speak to the owners at that point?
No, but I did leave copies of the law book for that and advise of these violations and to correct or reflect the file.
And these were repeated violations again?
Yes.
Did you prepare a report regarding this inspection?
Yes.
And was the report prepared in the ordinary course of business and as
ones along this wall were not working at the time. There was a lot of stays off, so we kept Robert full in good repair. And the next ones are the manicure tables. We didn't have the supporting manicure tables. We're supposed to have 10. And we still have them with the ones that he was saying he could stage us 2 per table. There's still 1 per table.
And did you take those photographs?
Yes, I did.
And are those photos a clear and accurate depiction of the school as you observed it on August 12, 2008?
Yes.
Now let's talk about the August 28, 2009 inspection. What can you tell us about that?
I did a re-inspection to see if they were in compliance from the previous inspection that was dated on 8/12/09, and I was the inspector on that. And I cited them in NAC 644.313.2, and this was like the Port County mentioned actually in different reports that all trash cans must be covered, and NRS 644.395, schedule of instructors still did not show they were in compliance, and NRS 644.085.2, their hair dryers were still not in compliance with having 10. And NRS 644.085.4, the manicure tables were still not in compliance. And NRS 644.085.1, the shampoo bowls also were not in compliance.
Can you speak to the owners on that date?
Yes, I spoke with both Ian and Gary Waysack in reference. Stated the statutes again for us and advised them that they were still not repeated the same offense, and they advised me they were actually interviewing the instructors at that time.
And did you give them a time frame to get the violations all corrected?
Yes, I gave them to October 1st, 2009.
And on August 28, 2009, did Mr. Waysack provide you with, I believe it's number 5, a list of instructor schedules?
Yes. And yes, I did.
Okay, and what is the significance of that document?
It shows that they did not have 2 full Cosmo instructors scheduled even in their scheduling. Like on, I think it's on the Saturdays, they were missing, and then the complaint also was that Gary was not present for his time between 9 and 1 on Tuesdays and Thursdays.
Now let's talk about the last inspection, which was on October 6, 2009. What can you tell us about that inspection?
There was a follow-up inspection, and I actually went with the Chief Inspector Andy Curtis and myself. And at that time, we still found the violations of NRS 644.395, and the staffing still didn't cover the 2 full Cosmos. And we cited NRS 644.400.1 because it left the instructors, one instructor was leaving at 4:30, and there were 19 students with only 1 Cosmo instructor on duty. And it was consistently between the hours of 4 and 5:30. And the night instructor didn't come in, and the night instructor came in was an esthetician and not a full Cosmo. And also we found that on Saturday's schedule, it showed only 1 instructor between the hours of 8 and 9. And cited NAC 644.085.1. There were still 6 shampoo bowls with chairs and 4 others that didn't have chairs that tilt back or chairs. Some of them didn't even have chairs with them. And then NAC 644.325.3 said all equipment must be kept in good repair and operating. And that was because the dryers were not with plugs. And NAC 644.085.2, there were 10 hair dryers, however, 4 of them were not operable. 4 dryers were operable, 6 were not. There were 5 dryers placed on a wall without an electrical outlet there. And NAC 644.054.4, and there were 6 manicure tables there, and we needed 10.
for repeated violations?
Yes.
And so what did you do on that day?
I basically started to file the complaint against destinations.
And did you prepare a report regarding that inspection?
Yes, I did.
Was the report prepared in ordinary course of business and as part of your duties as inspector for the State Board of Cosmetology?
Yes.
I have no further questions for Ms. Steele at this time, although I reserve the right for rebuttal questions. Thank you.
Okay, you are Gary Waysap?
I am.
Do you have any questions for Ms. Steele?
I don't.
Does the board have any questions for Ms. Steele?
I do. I'd like to know when your school was open.
The inspector.
Questions for
Oh, excuse me, Ms. Steele.
Ms. Steele.
I have no further witnesses, and I would rest at this time.
Okay, Mr. Waysap, do you want to present yourself?
I do. I have a packet for each of the board members that we prepared.
I have no objection that it be admitted into evidence.
In that packet, you'll find an overview letter addressed to each of the board members, and it outlines each of the violations and our current position and how we've actually remedied these. So after our last inspection, we did remedy all the violations, and I sent a letter to the State Board on January 4th outlining what we had done to resolve all the issues. And if you want, I'll go through each one step by step, item by item.
Is that needed? I would like that to put on
Okay.
the record.
So the first claim for relief on my cover letter, page number 1, sufficient instructors. So we've hired additional instructors to fulfill the needs of the students and to be in compliance. You'll see in your packet there's an attachment of our current schedule, all of our instructors, a copy of all our instructors' licenses. And though that actually exceeds the requirements, we have multiple cosmetology instructors. The issue before was we had instructors on staff. They weren't all cosmetology instructors. We had aesthetics instructors, nail instructors, so on. So to be in compliance, we hired additional cosmetology instructors and adjusted our schedule accordingly. The second claim for relief, adequate and operable hair dryers. We have 10 hair dryers, 9 hair dryers and a processor. At the time of the last inspection, those were in place and they were attached to a power strip. Unfortunately, the power strip tripped, and if I would have been there, I could have tripped it and put it back on, but they turned on several of those dryers and they didn't work. Since then, we've replaced that. All of those dryers and the processor are in working order, and we currently have 10 hair dryers and processors. The third claim for relief is sufficient shampoo bowls and chairs. We have 10 working shampoo bowls. We had a pump we were using for our pedicure spas that we would drain the pedicure spa. We removed that, put that in the back room, so that didn't occupy any of the shampoo bowls, so they were all in working order. We have 7 standard shampoo chairs and 3 shampoo styling chairs that are adequate for shampooing. So we can actually shampoo 10 clients at one time. And if you look in your packet at the photographs, you'll actually see that all the shampoo bowls pictured and clients being shampooed in those bowls so that they are operable. And then our fourth claim for relief, adequate manicuring tables. As the inspector stated, we have the double manicuring tables. Unfortunately, students would move those chairs around. They are adequate for doing 2 clients at each table, providing the chairs are all in place. And what happens is, and this is certainly our responsibility to make sure they're in place, but they get moved around. So currently, they're all in place. The double manicuring tables have 2 chairs that are instructed to remain there, and then the other 6 separate manicure tables have single chairs at them. And then the 5th claim for relief is our equipment to be in good repair. All of our equipment currently has been reviewed by our maintenance staff and is in good and proper working order. And just in closing, I'd just like to say we have had some violations in the past. Obviously, some of them were repeated. The instructor's schedule, we tried to remedy several times by hiring new staff, and for one reason or another, they did not work out, so we were always kind of at a disadvantage with our instructor staff. We've overhired at this point in time and have more than adequate instructors on our staff, along with a substitute teacher list, which is very helpful when someone calls in sick and we have someone to replace them. So just in closing, that we are very proud of our school. We're not just here to operate a cosmetology school. We're out to change our industry. We want to improve the industry, raise the level of professionalism within the spa and salon industry along with the schools. Obviously, we have an obligation to you, the board, to stay in compliance, and that is our goal. Our goal is to have a great relationship with the state board, again, raise the bar of professionalism. We invite you all to come down to our school. We invite the instructors. We've invited Vince to come down at any time to take a look at the school. We're in compliance at this time, and I know you guys are dealing with a lot of bigger issues today, being evidence of that, and I apologize for having you take your time with our school, but I can assure you that all of these have been remedied and they won't happen again in the future.
Mr. Waysack, I have a couple questions.
Sure.
I have one question for him.
Yes.
Mr. Waysack, if I understand your testimony, you're not disputing any of the prior violations, are you?
Well, yeah, I am. I mean, there's some gray areas in there. When they were in if I go through them point by point, the last time they were in there, they said there weren't enough shampoo bowls. There were enough shampoo bowls. They were disputing the type of chairs that were at those bowls. They were all there, but they were saying that they couldn't be used as shampoo chairs. But if you look at the photographs, we have someone being shampooed in one of those chairs, and it's sufficient for that.
Okay.
And then the nail tables at the time when they said there were not sufficient nail tables, the tables and chairs were all present within the facility. Were they set up to operate as a nail station at that particular point in time? No. But they were there due to the fact they were just moved around the school at some other location. So they were there able to do those manicures if needed.
Isn't it true that you were cited multiple times for the same violations?
Absolutely.
Thank you.
I'm looking at those shampoo bowls, and I have a problem with that too, with the straight chair that does not lay back.
It does lay back. That back part is we've adjusted those so they actually do recline back. They're in a slight reclining position, so they can actually be used as shampoo bowls.
These chairs that I'm looking at do not recline.
They don't actually recline back. The chairs, we adjusted those so that the back actually slopes back, and when it's put up against the shampoo bowl, it actually has an arch to the back so that they slide back into the bowl. And there's an actual person being shampooed in there.
Yes. Why did it take you 3 years to comply?
Well, I don't think it took us 3 years to comply. I think we were complying as we went along, and we remedied the trash cans, we'd hire instructors, we'd fix this, and then it would, we'd have the manicure table set up, they would get moved again, we'd get inspected. It was just kind of a comedy of errors. And we take responsibility. I mean, there were things that weren't done that should have been done sooner. We were working on different issues, trying to get them resolved as we moved along.
What I'm having a problem with is this is a school, and you're sending out licensees that are supposed to comply with the laws of the state, and you're not complying. And you've been cited over and over and over again for the same violation. And I have a problem with that. And so I'm going to ask the board if they have any other questions they would like to ask.
Actually, I have a question of maybe towards more of the inspection when they first opened the salon. Is it within inadequate equipment, how does the license get issued original?
I can, sure. The original license, the equipment was there when it was purchased. The problem that was, some of the equipment was moved from one locale to another. So when the inspection came in, there wasn't enough of them. They were noted that they were not in compliance. And the issue was that it repaired, and the next time it came in, there was a deficiency again. So obviously, the message was not being accepted, that it was mandatory to be there at all times.
We would, it wasn't like that we ignored these. We would repair them and, or we put them in place and they would get relocated. It wasn't that we were just not doing this. The manicure chairs are a good example. They were put in place and then moved, and then when the inspectors came in, they weren't exactly where they needed to be. And just so everyone knows that we had an inspection at 8 o'clock on Saturday morning, this previous Saturday, and they found absolutely no violations there. So everything was in place. All the chairs were where they need to be, adequate dryers. All the previous issues were resolved.
We have a copy of that.
No, we just went out on Saturday morning. We just came back to work today, so we haven't filed it yet.
But you can attest to no violations as of the 18th?
Yes. The 20th. We went out on the 20th.
Yes.
Saturday.
I have a couple of questions. You stated you have 10 hair dryers today and they're all functioning.
Yes.
What happens if you go back today and one has had a problem?
We won't. We won't have a
Then
problem.
you will not be in compliance.
Right.
Okay. When you went and got your license, were you given the requirements for the license so you understood fully that you had to have these things functioning every time? Okay. That's my concern, is that even today, one hiccup and you're not in compliance again. It's very disturbing that these young people that are going to school, that want this education and are looking for their license, are looking to you to educate them.
Right.
And it sounds to me like today you're not even capable of fulfilling that. So that's my concern. And I just wanted to know if you did understand the licensing laws when you applied for yours.
Right. I can assure you all the equipment is in working order and it will remain in working order. We will make sure our maintenance staff is up to speed. If we have to repair a dryer, if we have to put something back in place, it will be done. I mean, just so that the board knows, we have, we are setting an example for the students. We run a great curriculum. We offer programs that maybe some of the other schools don't, on business, on success, on professional development. A lot of these things aren't necessarily always seen by students. Obviously, we have an obligation to you to be in compliance with all the mechanical requirements. But if you look at our state board records, we have a 100% passing rate at state board for our students. So that's something we're very proud of, and that's our goal. Our goal is to educate these students and to have them pass state board and go out into the profession with a license.
But what happened to these children or these young adults or whoever's taking the class in the last year that they didn't have all of this equipment? That would be my question.
Well, if there was an equipment hiccup, it wasn't like they didn't have the equipment they needed. There was always equipment there for them to use. There was never a point where they didn't have what they needed. Obviously, there was requirements that we have to have these in place, but they always had shampoo bowls to use, dryers to use, manicuring tables, etc. There was never a point where a student said, "Hey, there's no shampoo bowl to use. There's no dryer. There's no, manicuring table." There was always sufficient enough equipment for them to be educated and to perform services.
Prior to this last session, were you aware that they were going to come in on Saturday?
Absolutely not. I mean, they were there before I got there, and but as I stated back in December when we did our last inspection, we repaired everything at that point in time. I sent a letter to State Board letting everyone know that it was repaired. We were all in compliance, inviting them back out for us to be re-inspected. This was back in December.
Ms. Fedoldi, did you have a question?
I have a question. I wanted to
go back on the chairs and the shampoo bowl, I have a concern. The person that you have modeling in this chair is a very young girl. Most of the school customers can be senior citizens.
Sure.
I don't see anything that will accommodate them and the flexibility of them accessing the bowls. What has your experience been so far? Have you had any problems with?
No, they're adequate. That's why I took the photographs. We were using those for shampoo bowls, so I wanted you to see that they have some evidence that they were capable of shampooing.
Well, I see her neck extended, but I don't see her back leaning back. So it's not accommodating the entire posture. It's just accommodating the head.
Right. She can lay back in the shampoo bowl.
My concern is for the senior citizens and handicapped people.
Right, and they could lay back there as well. I mean, the inspectors were out on Saturday. They saw those chairs. They're in place and they're workable. You know, they're shampoo bowls. There's I mean, being in the industry for as long as we have, there's all different kinds of some that are obviously more comfortable than others. Electric. If you put a footrest on any shampoo bowl, it relieves that strain in the back, so it makes it more comfortable. But I can promise you, there's probably salons out there and schools out there with shampoo bowls that are not as comfortable as those chairs are. And those are the European backwash style bowls, so that those are much more comfortable than a standard shampoo bowl.
Well, Mr. Wayside, you said you committed to this board, but you need to be committed to the public, first of all, in compliance with these regulations, not necessarily only to the board, and also a commitment to your students who are paying you for their education and for proper equipment and instructors. I think that my challenge is understanding your business, and these things happen, but this is a 3-year process. It took you 3 years to go get your license. And I understand maybe you had issues with that, but knowing that the first year you were having trouble finding employees that were instructors. So I'm curious to know why it took you so long to get your license.
Well, I applied for my license when we opened the school up, and I was going through the PIL program, and we lapsed over. We thought, my lead instructor and myself, that we had 2 years to complete those 500 hours, and I came down about 13 months after I completed those, and they told us it was a 1-year program. So it was a misunderstanding of that. So I was applying for my license from the beginning, as soon as we got our school license.
And it's a little bit concerning, and I think for the board, that you're in compliance today, like Koki stated, but we need to have some sort of, I don't know, I guess I would go into policy or disciplinary.
Well, and I'm inviting the board or the inspectors down there at any point in time, and if we are not, if you put something in place that they come out again and we're not in place, that whatever action needs to be taken. But I'm telling you today that we have everything remedied, and we will keep it in that.
Thank you.
My mates are really in the instructor issue, but as far as some of the comments you were making, as far as that if one of the dryers goes out or one of the shampoo bowls, the law requires a minimum amount, but we don't require them to have backup material. So any school or any salon can end up in that same situation if something goes out. And I thought about it when I was looking at the shampoo bowl. I got pictures on the chairs. I've got one that's adjustable, it's got the lever in the back, and it's for a style chair also. And actually 9 times out of 10, I end up positioning it like in the photo because it's actually easier on somebody's neck than laying all the way back. And he does have 9 other bowls for handicap. I hadn't thought about it also because I have a client who's in a wheelchair, and I can't do it in my room. So I have to wait for one of the end shampoo bowls to be available. So I was thinking that when you said that, I thought, there's only 2 shampoo bowls I can actually use in the salon because the other ones you have to get through a narrower area, but it's accessible but not really comfortable. It's really, as I went to maybe remedy anything like that, we'd have to change requirements to require backup materials, backup chairs, backup shampoo bowls, backup. But the law states it's a minimum requirement as long as you're fulfilling the minimum.
Mr. Waysek, you are not disputing the fact that you had all these violations?
No, I'm disputing some of the violations that when they were out, the nail tables. The nail tables and the chairs were there. They weren't in place. The chairs weren't at the table at that time. They were in the facility.
Why didn't somebody get them to the table with these pictures there, say, look, there, here?
A couple of those inspections, I was not there, or it was at night, and the night instructors, why they didn't put them in place, that's a
That could remedy right then and there.
Yeah, just pull them over and put them in place, yeah.
We actually had times where, there was times where there were only 4 manicure tables, even if those were the 2 that he's talking about could add 4 2 more to it, it still wouldn't have brought it up to the code. But I saw that he made an effort on Saturday when Jeff and I were there. I think we got his attention that this is serious, it's been an ongoing thing. And, the board has had to go out several times, using up the inspector's time and writing up these reports. It's a long process for us. But as far as if the hair dryers were to go out, we give a leeway. Like if it's broken, in fact, he had a problem with his washer. We're not like it's broken, you're going to get a side. So when we write these things up, they're not written lightly. I'm trying to understand them. And it's like if a hair dryer breaks, we'll give you how long will it take you to fix it. And we usually give you that 10-day, 2-week compliance because we understand things like that happen. But it's just when it's an ongoing thing. There's times I was there doing an inspection, and they were having to pull dryers from downstairs and bring them up. Well, it should be in the school walls of the school. I could see if one's broken and you're fixing it, but it should remain there, not bring it up because we're there now.
I make a motion to find Gary Blasak guilty of violating NRS 644395 based on his own admission and based on the evidence.
You want to do each one separately?
I like to do each one separately. Yes. Each one separate, yes.
I'll second that. Motion made by Ms. Benali and seconded by Ms. Booth. Any discussion on that? All those in favor? Aye. Any opposed? Okay, can we proceed on, or do we need to go ahead and do?
I think you might want to go through and do each of the violations. There's 5 of them. And then after you determine which violations you believe are guilty, then you can go ahead and determine the penalty.
So on this NRS 644.5, we need to go ahead and do the penalty on that. Or
No, I think wait till the end. Go ahead and do the other, determine whether or not there's a guilty finding on the other 4, and then do the penalty all at once.
we do have one abstention.
601.
And I make a motion to find Mr. Blasak guilty on the basis of NRS 644-400.
I'll second that.
And then point 1, 400.1.
4.1.
Oh, that's, I think you already handled that. That's one violation, 395. Yeah, so you've already done the first violation. I think you want to move on to the second
The
violation.
second claim for relief.
All right.
That's a different one, 644.
But same person.
That's the instructors.
And the next one would be the NAC 644.
Someone.
Want me to make the motion?
Right,
Go ahead.
I make a motion to find Destination Spa guilty of NAC 644-085, 1, 2, and 4, based on their own admission.
Second?
I second.
Okay, motion made by Ms. Booth and seconded by Ms. Benali. Any discussion?
I had a discussion. Didn't I hear you say, Ms. Inspector, that that the 10 chairs were brought up from downstairs?
There's, on several inspections prior, he has a salon downstairs, and I guess they're stored somewhere else. His maintenance people brought some dryers upstairs. Since several different inspections came, I mean, they had them available. It's just that they were not there. Some are portable and everything, but they would be bringing them upstairs. When there was times we let it go when they were brought upstairs, they're not in this complaint at all, because he brought them up and had them set up. The other times where they were not there, and another time when Chief Inspector Andy Curtis and I were there, they were on a wall, and he says there was a strip, but we couldn't find an outlet there. That he said it like had kind of like triggered or something, so it wasn't working, and so that was our concern.
And since then, we've actually created a dryer pouch and put those that used to be portable dryers into this dryer pouch. So it's a permanent fixture within the school now. So that it's not necessary for them to be brought anywhere. They're actually fixed there, and they're actually part of our reception area seating right now.
But not at the time of the inspection.
That was several inspections ago. Was that we did not have those.
And was the same violation recorded on each subsequent inspection?
Almost each inspection, there was either 1, 2, or 3, sometimes of the same violations as stated here. There's times it would be fixed, something would be okay, and the next time you go and it wasn't okay. Now, going out there on Saturday, everything was, he had the 10 dryers, he had all the chairs, the shampoo bowls. I was very pleased to see we had 3 instructors. There was an SD instructor and 2 licensed cosmos.
Brings to vote. All in favor? Aye. Any opposed? Abstention.
Oh.
Motion carried. The NAC 641.3253. Is there a motion?
I make a motion to find Destination Academy guilty of 644.325 and 644.110, 644.120, and number 3.
A second. Motion made by Ms. Good, seconded by Ms. Jones. Any discussion?
I just want to double check. We're on point 3. Is there a photograph, or is there some documentation where they weren't clean and in quick repair? I guess that was because the machines weren't working. That's the deal?
Yeah.
That's the deal?
Equipment's in there.
It wasn't working.
Take a vote. All those in favor?
Aye.
Aye. Any opposed? Abstained.
I do have a recommendation if the board's ready. Well, for the first violation, the first claim for relief, we would recommend the $2,000 fine, which is the maximum for that violation because it was a repeated violation, and we believe that the instructors, lack of sufficient instructors is a serious violation. For the other violations, we would recommend $500 each instead of the maximum $2,000. So the total fine we're recommending is $4,000 because it's $2,000 for the first, $500 for each, so total of $4,000. We would also recommend that the costs for the investigation and my time in preparing the complaint be assessed as well, not to exceed $750. I believe the costs are about $500, but I'd like to check and get a more accurate tally. You can handle those separately if you'd like, so you can do a penalty and then you can determine cost after that.
But will be the penalty phase alone.
Well, yeah, the penalty is for each of the violations that you found guilty. You found the first claim for relief, second claim for relief, third, fourth, and fifth. You found all claims for relief guilty. And so you can determine a fine or notification, whatever you want to do. But we're recommending a fine for those. And then after you determine that, you can also determine to assess costs pursuant to NRS 622.400. And we would ask that cost be assessed, like I said, not to exceed $750. And we would provide more detailed tally of costs to Mr. Waysack within 15 days of today.
Do I have a motion? I'd like to also add something to the penalty phase.
Well, I was just recommending, so you're free to do whatever you'd like. So that wasn't a motion or anything like that. That's just our staff's recommendation.
Okay. I'd like to make a recommendation as well. Because it took 3 years to be in compliance, and it took a third offense to consider these things serious, I want to recommend a probation of 1 year, pending satisfactory inspections to continue operating business.
We do need a motion. Want me to make the motion? And the fine is going to be $4,000, right? Is that what your recommendation was?
For the first.
Go through each violation. Recommend.
I'll do the first one. I make a motion to assess a fine of $2,000 for NRS 644395.
Yeah, you can do one motion for all of them, but just separate them out per cause of action.
And then 644 400. Yeah.
You can just say the first claim for relief if it's easier. So for the first claim, you're recommending if you wanted $2,000. For the second claim, what would you like?
The 500.
And then for the third?
500.
And for the fourth?
500.
And the fifth?
500. And I would also like to add probation onto this.
For how long?
And the cost of your fees.
Not to exceed.
Not to exceed $750. And the probation, I think, for 1 year.
Can we clarify the probation? That would be if it's done in violation of any of these repeated items, come back before the board.
If there's a violation of any of the repeated actions, that you would come back before the board.
A repeated violation of any of these five, is that correct?
Correct. Any of the 5 they're in here for today.
Second.
Motion made by Ms. Booth. Want me to go through it? Would it be better?
Sure.
To assess a $2,000 fine for violation of NRS 644.395, $500 for the violation of NAC 644.085.1, $500 fine for the violation of NAC 644.085.2, $500 fine for the violation of NAC 644.085.4, and $500 fine for the violation of NAC 644.325.3, with a 1 year probation
through the pass because of the snow.
When when you get to see her tomorrow morning,
Call this
let her
meeting
know
back
that
to
she's
order.
a whole big stack of shredding.
107. Okay, that brings us to item 19. Consideration and creation of research committees to research various topics of concern. Topics may include, but are not limited to, two-tiered esthetician licensing, regulations for threading, developing a comprehensive esthetician curriculum.
Madam Chair, this came out of the retreat that we had recently had, that the board had indicated interest in establishing some research committees to deal with the topics that are either facing us right now or sometime in the very near future. Mr. Leader submitted 3 topics that he had indicated on a list that he provided. Others have provided a couple of different possibilities. But what this topic has brought before you is that should we do some research committees and begin the process of collecting data and the different perspectives on the topic. And I'm recommending that we not do more than 4 at a time so the staff can keep up with it. And there's no reason to indicate that these 3 topics are absolutely mandatory, but they were thrown out as a possibility. And many of you may have different views of what would be the priorities or different topics that may come up. But one of the topics that we're going to have to deal with is the two-tiered esthetician issue is a dominant issue in the United States right now. A lot of states are looking at that. Some have already made a position. Others have not, like us. The regulation of threading, we're going to have to do that either way. That's going to be part of a regulation set of hearings that we're going to put on. The issue for there might be what would to assist in maybe helping develop regulations. At the moment, the original plan was for my staff and I to meet with a couple of input individuals from the field that know that they currently do threading, but part of the cosmetology operation. And they have some strong feelings about what kind of sanitation issues should be included to protect everyone. We wanted to meet with them, and we'll be meeting them, I believe, this week. Right?
Yeah.
So we're going to do that to sort of set the stage. The second part is we need to get input from the epidemiologist of the state, who's been extremely supportive of our position on the sanitation issues especially. So that one is going to be a lot of activity anyway, whether we make it an official subcommittee or an unofficial subcommittee. The last one, developing a comprehensive esthetician's curriculum. Where we are with that now is, so I've been approving the expansion on the esthetician's curriculums for the schools, and the 3 priorities that I put in that particular topic has been the schools themselves indicated they just didn't have enough time to teach the curriculum properly, and so they needed more time to teach it. Secondly, we were concerned that they're not teaching enough sanitation, or at least repetitive enough, that it becomes an absolute for them when they think about what they have to learn. And the third part was that new techniques and Nevada law that we were concerned about. The students are coming out, but they really don't understand what the requirements of the laws are. And so those are the 3 things that we've stressed in the curriculum approval. But the board may want to get into maybe what we could do is review the original aesthetics programming and say, what do we need to build in there? Do we want to make changes? And there's a lot of changes that could or could not happen are based on, I should say may or may not happen, based on how the industry is changing and some of the new techniques that are out and some of the new products that are out, and does our program allow for that adoption of those products or not, and what modifications would we like to make. So I'm just trying to salt the mine here, or at least fertilize the ground so it can be a topic where we bring up topics that you think, the first 3 or 4 topics that will start a research project. And then just continue until we reach resolution on it, and then we can replace it with others.
Well, it's kind of been brought to my attention that we need to have some committees right now, or do we need to just basically make this fact finding, and then once we get further into the regulations or whatever it is that we're looking at, then have committees?
Well, an example of the two-tier thing is really a philosophical decision-making process that the board has to say, what do we want? What do we think is good for our population here in Nevada? And then, once that's decided, then you look to the regulations, recommendations to it, and the regulation review. So I see that as a separate issue that we need to sit down, research it, have 2 or 3 members of the board party to that, and make some formal recommendation to the whole board and say, this is what we think we should be, where we should be headed on that item. Threading regulation, though, I think is more of a generic set of discussions that'll have to go before the regulation review process anyway, because we have to establish regulations for threading, because we have none now other than what's in the cosmetology category, and the legislature directed us to do that. So that's going to be a process we don't have to set up a separate committee on, but we're going to have to do that anyway. But I'm interested in some of the topics that have been coming up is how, we may have some strong feelings about the medical assistance issues versus physician's assistance, use of products that are currently prohibited, all the way through be party to and give guidance to the staff of how do we react when we hear the legislative health care committee meet. Do we want to participate in that, or we monitor it? Right now, the monitors. We don't have guidance from the whole board on what they think about that. So those are the kind of topics I think they're very important to our long-range planning, but we're going to have to take some positions. The regulation review is an everyday process. I don't see that as a separate issue. I think that's an ongoing process. So all of you will be invited to the regulation review to be part of it. It won't be a small committee that controls that. But I'm really concerned about like the two-tier program because I don't know where to go with it. I don't have any strong feelings one way or the other. Alex, Mr. Leader, is basically our expert on the board that has particular expertise in that area. But all the board members who've either been a cosmetologist for a lot of years or taught in the schools or what have you will have strong opinions about where we should go with this thing. That, to me, seems like a logical one. But there are many others that maybe you see as a higher priority.
I think another subject would be continued education in the penalty phase. I'd like to see schools get on board with us recommending for repeat offenders to take a very specific to what their repeated violation is, i.e., example, salon management or disease and infection, disease control class. Salon management, particularly for the people that violate the no license, practicing without a license, hiring people without licenses, because that's pretty much covered in some of those chapters, especially in salon management. I really believe it's a more difficult penalty having to go back to school and revisit that class. I don't think they would be as eager to just pay a fine and do it again. And so that's something I'd like to see as a discussion. And I'd like to hopefully get Mr. Jimno to get with the teachers and see if they could accommodate future penalty bases like this.
I know that Ms. Benaldi, she gave me a list, which I turned over to Mr. Jimno. And if you'd like to make a list of some of the things you're interested in, and maybe we can compile the information and then work on the committees that way. I guess right now, because we have these 3 items, and the two-tiered seems to be the number one thing that we're looking at. And I'm going to ask you if you would be, you want something to say, or?
Yeah, I mean, number one, I think I have maybe 3 things to say about the two-tier licensing. The first one is that our testing exam, the NIC, they offer a second-tier licensing. two-tier licensing is accepted in Georgia and Utah. And so that is an avenue that we could pursue. The second part of that, though, is why does two-tier licensing for aesthetics have to be separated? How come there's not a two-tier licensing for the nail technologist or the two-tier licensing for the cosmetologist?
Probably aesthetics getting a whole different arena now with the med spas and all of that. I think that's basically the reason, because they're getting a little more aggressive in some of what they're doing. So, and a lot of companies are offering medical aesthetics courses.
Right, the paramedical.
So I think that's probably why medical aesthetics is getting more, because before it's just basically, facials and scrubs and masks. Now where they're getting
lasers,
much more comprehensive
chemical peels,
and they're using the doctor's offices to assist. So I really think we should form panels for discussing, looking into these other services and be more proactive than have to wait until
a problem. So the second part of that pancake is we don't license medical establishments, and to be an esthetician, you're working in a licensed establishment. So it does open up a few questions on how the two-tier licensing would work.
Well, we do pass much about currently. There have been estheticians' rooms in doctors' offices that are licensed. That we currently do have some. So
there is that avenue. And then finally, just the third issue on two-tier licensing is the inspection characteristic. Is when the inspectors go into establishments, are they having to determine which is the higher tier licensing performing which services and which is the lower tier licensing performing which services? And are they getting a true picture of the lower tier license not performing upper tier work? And then just from an investigative staff, that's what I'm more curious about, is how does the how will the investigators see that or greet that as a challenge or as a...
They can ask, why is that pick line? Why is the person have an IV?
Yeah. Why is that second tier license doing a trichloric acid peel or something?
My sense is that there's a lot of issues underneath that particular title. Mostly has to do with a nationwide effort by a particular group. NCEA is pushing two-tier licensing.
They're not now. They just came out with a new report.
Well, they modified because they were catching a lot of back push from their positions. So the issue is that some states are moving that way, some are not. They're very concerned about it. Mr. Austin had to deal with the problems with the MA issues, and that is now being discussed before the legislature on what is of MA and what do they perform, what kind of training that they do or don't have, and how it affects our industry. And he defended us quite nicely, but there was a lot of issues that came up that are really not resolved by either the medical board or the other associated health boards that we interface with. So it's a dialogue that we need to have take place of what we think about it, so then I know which direction I'm to be heading as your representative.
And then just as the final issue is, once, because I've also worked in medical practice as an esthetician, and one of the concerns that I have is making sure that folks who have that skill training then don't go back into private practice in a licensed establishment with the assumption that they can still perform some of those duties because they've been trained or they've received certification. And we are restricted from what we can do in a private cosmetological setting separate from what we can do in a medical setting.
I've been hearing rumors that people are being told, not by our staff or anybody in the industry, that we're aware of, they're believing that they come to get an aesthetics degree or certificate licensing, and then they go to a medical doctor to work. And they don't understand right now the position of the board and the interpretations of the law is that you can't perform as an esthetician in a medical spa or a medical physician's arena. and they think that's the normal route. So there's a lot of different messages being delivered that really aren't very clear for the new practitioners. And some of the doctors are, a little background, is the legislature wanted the medical board to take a position once and for all on MAs or PAs. MAs being medical assistants and PA being physician's assistants. I sat through a couple of the board meetings for the medical board, board of medical examiners, and they basically decided that whatever the doctors wanted, they were going to do. And they crafted regulations to fit that. They sent it to the legislature, was absolutely thrown back at them by the LCB, the Legislative Council Bureau, indicating that they were in conflict with a lot of other laws. So now they're back to square one, redesigning it again. But the real issue for the doctors is following the money. The money is more lucrative for them to have lower paid employees who can do tasks like injections and other applications of certain pharmaceuticals that only trained technicians are supposed to do. And trained technicians were considered physician's assistants. Now there's this dialogue going on of what that's going to be allowed, and we're going to get caught in the middle of it by accident because we can't control either one of those decisions. But we should have a position on it. And so I think the board needs to help me craft the position. I know David's been involved in this dialogue over and over and over, so I would really appreciate for him to be involved and others in the board that are interested in that sort of thing. But I think we need to take a position because we can't float forever. And so that's one I think is a great subcommittee that deals with that topic. There's no requirement by us to have standing committees unless the board feels a need for it. Generally, we see the need for ad hoc committees or committees like research committees. Because then you formulate a position that eventually ends up in a policy or a decision that we're going to change the law and go after a change in the laws, regulations. So those are very critical positions for us for the next few years. I'd like to get those started. As far as like a personnel committee, we don't need that because the way we structured ourselves has been effectively handled. So we don't need to do that. So we need to say, what's bugging you about the system? What do you think we need to be working on? I know what I think we need to be working on. I can advise you of that. I don't know what's in your mind. This discussion hopefully will bring it out.
I think just as an adjunct to that, Mr. Jimno, is that in developing the comprehensive aesthetic curriculum, that is coming out of the increase of the hours. So going from the 600 to the 900. And perhaps a lot of what my concerns about the two-tier licensing, I think a lot of that can actually be addressed through the development of the curriculum. Because if we now have as a state 300 additional hours that are going to be required of the aesthetic student prior to graduation. And maybe some of what people's interpretation of a two-tier licensing would actually be part of a more comprehensive curriculum.
And I believe that the two-tier licensing, before I became educated on the subject, was one tier being the aesthetic license, the other tier being the medical assistant license, and concurrently made up the tier. I didn't realize we were going for a lower level esthetician and a more higher level esthetician.
Well, and I think the issue for me is that, the higher level esthetician really is just staying in beauty school for a lot longer. So they're leaving beauty school with a master aesthetic license. And I'm not quite sure that sends the right message to the consumer.
I'm just on the outside kind of looking in. When I seen the two-tier level, I kind of felt like the second level would be somebody that would be doing the chemical peels and have that knowledge, that just as the general public out there that would have more knowledge of how to handle those chemicals and be trained in that area. Because I would hate to think that somebody was putting a chemical peel on your face that had no knowledge.
I think what you'll find is that the manufacturer is providing that certification, not just a license to do so.
But how are they giving a certificate? I don't know. I just think the second tier. I would think that we should be involved on that second tier for that training, because who's training these people? Somebody goes in for a day and gives them an 8-hour class, and now they understand how to do a chemical peel. What happens if this happens? So I think that would be the concern of the general public. I would like to see somebody that is applying those types of chemicals, or if I've had cancer or something like that, that is applying a chemical to me, how are the chemicals going to interact with the chemicals that I have in my body? So I really feel that I want somebody that was a little more skilled, had a little more education in what I was doing.
And I think my interpretation, excuse me, Mr. Austin, is that 2-tier licensing is going to be coming out of the beauty school. That's my interpretation of it.
Just to add on to what you're saying, and also depending on the strength of the chemicals, that's why you've got these medical spas that use more aggressive chemicals. And the reason they're done in medical spas is because there's either a PA or a physician on hand who would know what to do in case of a reaction. The very reason the issue with MAs, inject or not inject, well, the doctor's supposed to, they can inject, but the doctor's supposed to be there in case somebody has a seizure or reaction, because even a nurse is not allowed to diagnose. Only a doctor or PA can diagnose what the situation is in a lot of situations. So, for example, when you asked me that, you mentioned that the company that makes the chemicals will train. The company that makes one of the major injectables trains. They don't ask whether you're a doctor, nurse, PA, or an MA. They will train you and certify you. Just because you're a physician doesn't mean you are aware of how to use that product. You could be just a medical assistant, be aware of how to use it one physician. But if something happens, the physician knows what to do with the reaction. Same thing with the chemicals. So what I would say is you need to be trained and certified by the company that manufactures it. But on the other hand, if it's a strong chemical, it needs to be done within a certain proximity to somebody who knows and handle what in case something goes wrong. And that's why the subcommittee is so important. To create actually recommend guidelines. And
I agree. I just wanted to comment. I worked as a medical assistant for 5 years, and I can honestly say that I gave injections, I did IVs and so forth, but as far as knowing anything about any kind of injections in the face or peels and things like that, there was no training at all in that. So unless they've changed all of that, they have to be learning it from wherever they're working. It has to be a doctor or nurse, somebody's has to be giving them on-site.
I was trained on site.
Classes, lessons, however you want to
In
learn.
2 hours, showed up, because I worked in a doctor's office too, plastic surgery center, doing that without, So yeah, that's what they do. And then the doctor takes all responsibility.
And then how would you have felt coming out of beauty school with a license that said, oh, sure, go. Yeah, you've got that
The way they're
second
turning out
tier.
people now is
Unbelievable.
unbelievable.
It's better to have 6 hours worth of 600
Better
hours.
2 hours.
Yeah.
That is
Sarah, we're back on this because I was talking to an attorney and all this was going on. For example, Botox injections. Okay. The couple that made Allergon, which is the company that manufactures Botox, had trained to give them an actual certificate that I saw that they had the training. So let's say somebody's working in a plastic surgeon's office, trains you to inject Botox, but you're not certified by Allergon. I was explained, it depends what attorney you talk to, that they have a legal, Allergon can defend legally the ones they certify. But the medical insurance may not cover, that doctor's insurance may not cover, let's say you, for example, because Allergon's saying, hey, you know what, we didn't train you, we didn't certify you. That end may be certified. So that's unreasonable as to us explaining.
Well, it depends. If there's an injury, people are going to sue who they can sue. They're going to try and sue the manufacturer, the doctor, the person who did the injection. And it just depends.
What the insurance will cover.
Yeah, it depends on the policy that they have, It depends probably on the supervision of the doctor too. Do they know that the injection was happening or not? And it's going to depend on a lot of things.
So the subcommittee should be discussing exactly what the breakdown of these people are.
Recommendations
Yeah.
of what
Would we call this a research committee?
It'll be a research committee to
Okay.
help develop a position by the board.
What I'm going to do is ask for 3 volunteers. Does that sound good? 3?
course, you haven't any medical spot in the facility I'm working at.
Now,
So
as I said at the retreat, I expect you guys to work too. So we're going to have a team pull together that will help figure out where we get information, who might know about which group, and how we track it down. So we can make.
Would we be able to utilize a staff member? I mean, we notify
Oh yeah,
you.
I'll be involved.
Yeah, because I'd like to be able to figure out maybe how other states are also addressing this as an issue.
That'll be one of the issues, is what are other states doing?
And then I'd also, I mentioned this before, is that when we have the opportunity at the NIC conference, if we have breaks between sessions, I still would like to have some type of aesthetics roundtable, so we can, as our committee, we can present back just what the NIC folks are doing. So if there's ever that opportunity,
It possibly could be Saturday on the arena.
Yeah.
One of the things is going to be strategic is if we have two members from North, maybe I can work a deal where Mr. Austin can come up with me and we meet and have a working session, that sort of thing. But the idea is that over a period of 3 or 4 or 5 months, we should be able to begin to gather real data instead of assuming a lot of things. So that would be a good one for the long term because it's a problem where it's not going to go away. We're going to continue the next year or two, no matter whether we do anything or not. We want to be in the strongest position, at least understanding what we do. So that sounds like a good one. The regulation of threading, I think instead of having a subcommittee, what we'll do is I'll be convening meetings on that because we have to write the regulations. Those who are interested in that sort of thing, let me know, and I will include you in the group. But either way, all the board members are going to deal with that eventually because we're going to have to bring it before you in a public hearing either way. And you recall the style I used last time was a town hall type meeting where we can get a lot of, anybody who wants to talk about it can come. And then when we formulated the regulations, we then went to a regular public hearing, which is required by law.
Mr. Chairman, I did want to just ask too on that threading. Was it that they were considering threading not a depilatory?
That's correct. It's in the law defined that way.
So
they took it out of the definition and said it is no longer considered depilatory in the men.
And so what was that considered if it's not a hair removal technique?
It's called a hair removal technique, but it's not called a depilatory. So we are going to be invited on that item, 2 things. The legislature required us to set the regulations for threading. We're not allowed to charge a fee of any type. We have the right to inspect the places and certify them that they are certified, I forget what the term was, registered with the agency. And then lastly, we have to come back in 2011 session with a report from the staff, the board itself, that says what the results of all the 2 years was all about. Do we have problems? Is the regulation in? What impact did they have on society if we have any problems with diseases or anything like that? So we will have an option to report back. My sense is it should have never been removed as depilatory, but they did. So we obey. But we're going to be going through regulation review, which we will have little or no teeth at this point until regulations are crafted, because there are none. And so we'll have to create them.
If we recognize that it should be considered depilatory, therefore the course at schools would teach that so that they could be licensed, or are we going to regulate it without a license? It just seems odd to take a part of an entity out as an exception. That's why I
It was
asked.
more than odd for me.
The legislature did.
We didn't do that.
The legislature did.
We thought it was part of our curriculum,
So
and they said no. So those people don't have to be left, because those people did not want to go through the course. They just wanted to do threading.
It all started with us just getting clarifications because we had populations from India in the East who wanted not to be regulated because it was customary in their previous culture. The the senator in charge of the Senate Labor and Commerce Committee, the chair, decided to cut a deal on that and began taking the depilatory out of the deal and then pulling it out of what was in the cosmetology scope of work to start with, has been for many, many years. So we opened the door by accident, and they just went through it and got them deregulated right away. And the compromise was the Assembly didn't want to put up with the Senate's position, so this is the compromise what we've got now. And the reason they did that is to keep it in our jurisdiction, so it would be appropriate for us to come back and renegotiate it in 2011, hopefully.
If we're not regulating, when you go and inspect, what are you inspecting?
Sanitation,
Just
infection control.
sanitation. So if, let's say they're not doing things properly, they still would not come in front of us.
Well, that depends on the regulation, because regulation becomes law if it's approved by the legislative commission. So what we do is we'll craft regulation.
Well, I mean, like right now, I was referring to now.
Right now, we can't do a thing about it. All we can do is collect their addresses, you know who they are. We're certified. We're getting them to apply for registration. That's as much as we can do at the moment.
And compile a statistical problem, particularly if that legislature gets something happens.
So that's, in other words, you're just out there looking and writing things down, and
At the moment, yeah.
as you said, you don't have any teeth, so you can't do anything.
The staff will be starting to work on. The staff will be working on creating the regulations. That's what our meeting is later this week, is to help give us ideas. So we probably have everything in our head, but by having a couple of good practitioners that are trustworthy, it gives us other ideas we might install in our thinking.
Okay, we don't need any subcommittees for these other two items right now.
Well, I don't know about the comprehensive.
That would fall
under the
what-
two
what are
tier.
I would think it would
tier?
fall under this thing. Actually, all three of them work the same.
I have a question, going back to the regulations and gathering information and research. Can we utilize our inspectors to report on what they have seen?
You know, that's what they're doing now.
They are doing that now?
They've identified all the
Compile a lot of their findings
practitioners.
in.
There's not a lot of them. How many did we talk about the other day?
Individuals.
We only have actually about
That's a good enough
I
test.
think there's probably going to be a dozen kiosks in our state, maybe 2 dozen at the most, and maybe 50 or 60.
That's a good enough pool of people to say this is what's going on based on our test subjects.
Yeah, they've been monitoring for some time. They've been digging up all the identified locales, who the players are. So we're hand carrying requirements for them to register with us now. They are dealing with that. And then we're starting the process of developing the regulations. And the biggest contributor is going to be probably the state epidemiologist about what is needed minimum. But other than that, we have some guidelines from our current regulations that we can say, those fit this thing too. Our problem is they're kiosks a lot. Some of them are kiosks, some are standalone little shops. And the shops can have running water now, but the kiosks can't. So there's a series of issues we got to figure out. That's what we're working on now. So my sense is the first one that you listed is okay. And that takes in number 1 and number 3. Is there any others you guys can think about?
Well, and I guess I don't know if this is an agenda or new policies, but creating policies or some type of working on some type of regulation to ensure and protect the licensees or us from the licensees. If we're in a situation again where we have people that have to surrender their license or anything like that, is there a policy we can put into action or that we could say, we really don't want you practicing until everything's cleared up?
The issue there is it's a legal issue that I don't think we're going to get around, and that is, if you've been accused of something, you can't be prohibited from doing it unless there's significant danger to the public. Now, if the challenge, like we had today, was for not having a license because you didn't go to school and you didn't prove your case that you're competent, then we could possibly make the argument that it's dangerous to the public, untrained people. In this case, we didn't challenge their training. We challenged their documentation that said they were eligible to even get the training, but we didn't catch it. And we didn't know they got their license on false documents. We can't stop them. That you're just going to have to accept. That's the same in regular law. I mean, a dealership that sells cars can't be prohibited from selling cars until they've actually been tried for fraud and criminal activity before they can be their license withdrawn to allow them to sell cars.
They're innocent until proven guilty.
That's the theory.
The only time I've seen that different is sometimes with the subsequent request for continuance. So I had one where this was a different client, but they asked for continuance, they were given it, they asked for a second continuance, and the only reason the second one was granted is they had to stop working until the case. So that was the condition the board, they gave before they granted. So that's the only time I've seen it, and that's really where they agreed. I mean, they're agreeing, okay, yeah, if you wait another continuance, we'll do it, but otherwise, no.
The ones that you see those kind of summary suspensions are usually doctors, lawyers that have major cases that are coming before the courts, dentists who could hurt people, those kind of folks. Otherwise, they don't.
And I think you could do it here. I mean, if there was a string of infections or something from a certain place, I think you could close. But it has to be, we have to have substantiated danger to the public.
A typical example of that is a MRSA breakout in one of the establishments, or an infectious bacterium that is contagious to people. We could close that shop on an emergency basis, and we'd be scrutinized very, very closely.
Is there any way to, on the same thing that she's talking about here, because I find it very frustrating, to charge them to check their social security number when they come in so as not to waste our time down the road here?
It's not the issue of the cost. The issue is we don't have a vehicle to actually do it that we're allowed by the federal government. They don't have a vehicle for us to do that. The only thing that the federal government has done is they decided that if you hire an illegal immigrant as an employer, you have to check, and they've got a vehicle which you check on. I forget what they call it, but you can put up to 500 or 600 people's names on a list, and they'll check them quickly for you. Unless we have a criminal investigation going against somebody, we have no route into the Social Security to get the number or to validate it. In other words, I asked the question, can I check every licensee who applies as part of the background? The answer is no. We don't have any vehicle for that. But if you have a criminal investigation, we will answer you. And you see the answer we get is very limited. It's a yes or no, or it matches, it doesn't match, or it's never been issued. That's all they give us. And it's not even, they don't want to even put on letterhead. They're so skittish about it because the legislature in Washington has not really told them they could do it that way. So they limit their vulnerability from their side. Well, until we have that vehicle, we're just not going to have the vehicle to do it.
Is it in writing that we are not allowed to do that somewhere?
No, in fact, the law allows you to do it. They just don't. The laws we're researching the laws now. It says that we have the right to confirm, and we do. We have the deadbeat law, which we collect Social Security as required by federal law. But they don't allow us a vehicle back in to check it.
So if you ask somebody where did you get your Social Security card, and they said Florida, there's nowhere even in Florida we can check to see if they had,
No.
if it was a viable.
They can tell you anything they want, and they show you cards that are, most of the time the cards are fraudulent documents. But the issue, what we found it, is most people who get caught at it will snitch on others. They turn in other people voluntarily because they said, I can't do it, so they can't either. That's how we find out. But there's this belief that if we just call the federal government, they'll check it for you. There is no truth to that. We have the same problem with weapons in the law enforcement field. They talked about allowing us to have an instant check system, but there is no system to check on. So that they said, oh, you can do it, but it only costs $2 billion to put in place. We had no system. So that we did that for years and years and years. The law was there, it was created. Same thing here.
Do we want to discuss this further, or do we want to?
Yeah, I just need to know if you want, what other subcommittees.
Do we want any other committees at this time?
I think it'd be great if one committee could address these three, as they're somewhat related.
Well, that would be this.
Yes.
Throw the threading in with you guys.
While you're up.
I don't think we need to throw a committee for the threading. I think we're going to have some discussions. You guys will participate in that.
I think that will involve all of us. I think the 1 and 3 for this research committee.
If I was to understand, Mr. Jimno is actually going to do more of the legwork on the threading because it's policy making internally. You have to create a registration form.
We're doing all that.
Yeah, you have to have a whole system.
It's the
in place.
regulations.
I mean, I don't see that as us being able to help you initially.
Until it goes before the regulation review
Right.
process. One last item that you should be aware of. I'm probably going to come forward with a resolution or a suggested resolution to the surety bond problem we've been having for some time. I've held several meetings, and we get the same place every time. We never get past what's acceptable by all parties. And the two parties that are really at different positions, one is on the $400,000 required bond for those new established schools, and the other is $10,000 for the old schools. That is still a sore point all the way through. My sense is unless the board directs that they want to handle it differently, is I'll just try to figure out a middle ground that I think is workable for both sides of the equation and figure out a graduated approach from where the 10,000s are now and slowly grow them into something that is close to acceptable for both sides. Right now, 10,000 doesn't cover it, but 400,000 you can't get anymore. It's almost impossible. So somewhere in the middle is reality.
Why is that?
Because the insurance companies require you to put collateral that matches the 400,000. They don't just give you insurance money. They want you to put your house and all your assets against it, and people can't afford to do that. So basically, it's inhibiting. It's getting in the way of the creation of business and jobs. We've got to figure out what's more acceptable.
And the bond's required for what purpose?
Surety bond is put in place to protect the students. They put up a lot of money to go to school. Some are funded by the feds under student loans and grants. A lot of people put up the money. So you have a daughter and you have the ability to pay $18,000 for a cosmetology degree. The school goes broke in 3 months and you're out $14,000. The bond is to cover them, and 10,000 doesn't cover it.
And actually, we had a school where 400,000 didn't quite cover it either.
Got real close to
Could maybe, if you're doing something like that, work in conjunction where they don't pay everything up front, so that they're paying it maybe in a quarter or something like that, so that all
That would be with the insurance company.
And we get involved in the contracts with the school, the students.
Oh,
are
that's
how they
true,
pay.
yeah.
So,
We're not involved in the business itself. What the surety bond does is say, you must carry a policy that is dedicated to refunding monies that is owed to students when your school collapses or goes bankrupt. And so that's what that's intended for.
You're right.
And we get a lot of school owners that like to say to us, well, we have a credit line with the U.S. Department of Education, and therefore we should be treated differently. What that really means, they don't really understand it, is that means that the government doesn't trust them either. And they make them put a credit line that has to be dedicated for the U.S. Department of Education to get their money back. That's what that means.
And that still doesn't help the students who pay cash.
The regular students that are not funded by the feds, they're left out. So somewhere in the middle is going to be a recommendation that I'll bring. I tried to get a committee of the board, a number of you participate in dialogue, but we keep getting to the same place all the time. So I'm going to try to draft a compromise that hopefully will be at least acceptable or a good place to start to get towards the final discussion. Now, do you want that to be a formal committee, or do you want me to just go ahead and draft that and bring it forth in the
I think you should craft that and speak. Mr. Jimno, I think that you have a very clear understanding of the convoluted method that they have determined 400,000. Because, I mean, if you actually did the math through the way that the regulations allow, it can exceed the 400,000. And so 400,000 was the compromise. I think if you can kind of scale that back to something that sounds readable, you seem like the guy to be able to do that.
I think we should vote on that so it's clear on the record that we can do that work. What I mean is,
perhaps the chairperson could work with you. I mean, do you feel that that's an area that you would?
Oh, I feel comfortable.
Yeah, I would feel comfortable too. So. If you need a motion.
I think what Mr. Austin is saying, he just wants to be sure that you guys all.
like everybody's in agreement. Doesn't say they vote. Everybody's in agreement.
That's all he's asking.
Yeah.
I think the record, if you guys are, if the board says to me as a group,
opposed.
yeah, that nobody's opposed to that, I think the record itself will show that.
I think administratively it would be very well handled by the executive director.
The grandfathered schools may not like that.
That's why we're giving the test.
Do we need a vote?
Well, we just talked about moving before sometimes to make sure everybody's in agreement, even on things that aren't really of major to still dispose here, so we're clear on the record, that's all.
Okay, then let's
And then I definitely would like our board chair to participate in that because we already elected our board chair to represent all 6 of us in our absence. And so if the 2 of you are working together to achieve a good result, I would well suspect that might help. But that's my opinion. So, I mean, certainly I don't want to dictate my opinion to the rest of the group. But if you don't go my way.
Okay, we need a motion or we just need a vote?
I think if you're going to vote, it's clear, it's a good idea to know what you're voting on, so someone should probably say.
All right. So we're going to make a motion that we have, as a board, have decided to have Mr. Jimno in conjunction with our chair go over the issue of surety bonds for the schools, research and come up with some findings.
I second that.
Is everybody in favor? Sorry.
Motion by Mr. Austin and seconded by Ms. Booth. There's no discussion, I take it, so we'll take the vote. All those in favor? Aye. Any opposed?
Madam Chair, just to make the record clear, I think it would be wise for you to do the same thing with the formulating a committee to deal with the 2-tier issue and developing a comprehensive institution.
Since the board is appointing a committee, it's going to be a formal committee, I think we should vote on it.
Okay, so that would be a research committee for the 2-tiered esthetician licensing and developing a comprehensive esthetician curriculum.
And it's going to include
Alex Leader, David Austin, and Jeanette Benaldi.
Can I make that motion? Is that what you want us to say, Sarah?
Yes, please.
I make that motion.
Second.
I'll second.
Motion, Ms. Booth. Seconded, Ms. Jones. All in favor?
Aye.
Opposed? Motion carried. Okay, we'll move on to item number 20. To review the treasurer's report for October, November, and December of 2009. Is there any questions or? Any questions?
I will speak to this.
Okay, so do I have a motion to accept the treasurer's report?
I'll make a motion to accept the treasurer's report for October, November, and December 2009.
And I'd like to second.
Okay, motion made by Mr. Austin, seconded by Ms. Jones. Any discussion? All
I
those in
did have one point of discussion. I'm sorry, I did. It was that 457B. What did that mean? on
That's
that?
the deferred compensation plan. The employees
That's what
can
that's called.
elect to participate. We don't pay into that for them. That's just a deduction from their pay.
And that's just what the plan is called?
Yes.
That's
Yes.
federal requirement.
Yeah.
That's the first time I've seen that. Was it called something else?
No, it's been set up that way.
457Bs,
Yeah,
different types of plans.
because we're state employees, so,
Yeah, 457 is just the
yes,
title
state,
for state employees. It's
Mhm.
401K for private employees.
private.
Okay, we'll take a vote. All those in favor?
Aye.
Any opposed? Motion carries. Moving on to item number 21, the executive director report. Period from November 20th, 2009 through February 5th, 2010.
You notice there's a lot less verbiage on it because things are going well. The Las Vegas operation is running pretty smooth. We're all done. Obviously, we've been done with renewal for a while. So I'm using the flexibility of flexibility in the budget to use temporaries to clean up old files and archives. We're just about pristine nature. We've got a little bit more to do. That's about all that's really going on at the Las Vegas office. Everything else is running pretty smooth. Morale continues to be reasonably high. The Reno office operation is running real well. We are in the process of completing, and you'll see hopefully in the next less than a month, the completion of the expanded offices and the relocation of the small office we have up there into a full-service office in the Reno area, which will include the different testing processes, which has two separate rooms that does all of that, like we have here. Conference facility for the board when we meet up there. That's separate from the meeting room. And I think you'll like it a lot better. It'll be a full-service office. That is in the final stages. We're waiting for door jambs and doors that took about 5 weeks to order because they wanted us. People who own the facility like what we did here so much, they want to copy it as close as possible, which was what I originally wanted. Secondly, we've already ordered the furniture. It's due in about the same time as the doors are. And so sometime in late March, or at the very latest, or 1st April, we should be moving into it. And in the inspection unit, I've been meeting with the inspection unit to help identify issues of addressing, examining how we do business and creating better reports. You saw one of the outputs of those series of meetings with the destinations case, very detailed work. I want to compliment the staff on how they put that together. There was a lot of evidence and tracking of information and photographs. They did a really nice job as a team, especially Ms. Curtis and the inspectors in her staff of Kevin Steele and Jeff Green, who helped build the report, Pamela primarily, and then, of course, Ms. Fitzgerald, who also was the years out in the inspection and working with that particular prosecution. But hopefully we'll get models that you guys will see that'll be consistent time after time that you can easily read and understand when the evidence is presented. The computer-based testing project is complete in this office, running smoothly. We've not had any complaints from it. Everything's running pretty smooth. The only complaint we've had is the Vietnamese folks do not like the translation in there. Looking closer into that, they say that translation is not always as it appears. And so I'll be looking closer. But there's got to remember there's a lot of dialects in Vietnamese language. We are installing the equipment, the furnishings for the Reno office to do the same thing. And as soon as that's complete, then I'll be looking and ordering the computers for the actual room, and we'll have a duplicate of what we have here. Consistency and modern technology will allow us to increase our volume tenfold if we have to. But the only thing we have to provide is a few more monitors to make it happen. But the rooms are prepared for it already. Versa regulation project is running smooth as glass. We've resolved all the problems that we know of, and we're troubleshooting new design work that we installed, that we created. Ms. Blasco created an accounting process that had never been seen before. Yes, we have a few anomalies we're working out of that, but I'll tell you, it really does something special, and I can't brag about that too much. Debbie did a great job, her and Nadine. Even Versa says they've never seen anything like that, and they're trying to figure out how they're going to put it in their base system. So that's real prideful on our side. Lastly, on that issue, I'll be meeting with the president of Versa and the regional sales manager. They're going to put an offer on the table regarding the laptop computer, notebook type field units, and the software that goes into the Versa system. By the way, we already equipped now to do a lot of things on the online that they're designed. We're either waiting for enough backup material so when we put it up, people say, oh, it's worth looking at right now. But we are starting down the path of noticing things, articles. As we get caught up with it, we'll be able to post articles. The new laws that, remember, we haven't been able to get a book printed for ourselves. That's all been posted now on the internet, and people have access to it. We set notices, 2,000 notices out to all the establishments to let them know where to look and what's there. We are getting calls. We know they got this stuff. And we also are hand-carrying notices to the establishments by the inspectors to repeat pass to be sure the notification is solid. And we're also passing out the threading notices about you have to be registered with the agency. So all those projects are doing very, very well. And I think things are going at a pretty good pace right now.
Anybody have any questions? I have one question. Did I understand you right? Because I was looking at what the inspectors did today. There's a lot of work that they're having to do by hand and everything. So is this system going to allow them to take a notebook tablet out there and do the reports that way? Is that what you just said?
Yes.
What
it'll mean is the type of laptops we'll probably buy are called like pads, notepads. So we will put macros into the software, and the macros then are the forms we use, and they go in and they check them off, and then they sign them, and then they can do a supplemental report on a continuation sheet, and then we should be able to have small printers in the cars or at their disposal, so they can print a copy for the inspected per place, and then they have it all in the computer. When you get back to the office, they can download that into the software system that we have here, and it syncs it up. The issues that we're going to have to deal with if we're to do it doesn't like what they call VPN connections outside, which means that you have access to the network from outside via telephone connection or internet connection. We have to look at the security level of that. That's one of the few questions I have. But what they can do is they'll sync in the morning, say I'm going to route 16, 18, and 20 today, or those are the routes I'm working on this week. They can sync them up. They get all the information on those routes from the base computer system. They do their routes. When they come back in, when they sync again, all that drops into the machine automatically. So it saves a lot of pencil and paperwork. And we're hoping to make it so it's instantaneous information that's up to date to 8 o'clock that morning. So it'll be very, very modern, easy to use, and should be quite labor saving.
After the last grade, send you the receipt right to your email. That's the way we can do that. Once you find out about that internet connection, the security of that.
Now say that again?
Well, the report, they wouldn't have to print it. They could just email it to your site. Then you'd have your own receipt. You could print it up. So once they write the report on the pad or they do the report, they could just send it to your email, and then you yourself can print it up as a business owner.
Yeah. And that we'd like to see happen. Right now we're in the process of collecting emails for everyone in the system. Some people know how to use it, some don't. The reason we'd like to see that is whether we do that or not, or give an instantaneous report right then and there, is that we'd like them to be able to notify them by email the entire system at one time. They're called e-blasts. E-blasts can be delivered to all 20-some-odd thousand licenses at once. We can't do that today because we don't collect email addresses. We are now. It'll take a way we can modernize the system to increase notification and documentation to get it working. But we're going, the intent of the vision is to leave this place at the top of the mark, cost-effective, paid for, and working at a very high productivity. We're almost done with it. 85%.
Are the inspectors, are you excited about the laptops? And are you excited about the iPads? Yeah, I mean, because I noticed that just even handwriting the license number with the name, that must in itself take a good 10 minutes.
And I'm the one with the bad handwriting. I always get a lot of complaints about my handwriting.
When you have someone like Davis before you, it takes you 4 sheets.
Yeah.
Some have long business
Oh,
owners.
and they all got 6 names.
No, that's exciting.
So it's great.
I was surprised at how much work you guys had to do. I'm like, there's a lot to it.
Madam Chair, I have one more item before you get to the final couple items. I'd like to compliment the board today and the staff. The retreat we went to addressed a lot of issues. And one of the things a compliment I got from Mr. Nelson, who commiserates with me every meeting, said that he had a lot easier time of dealing with the minutes and how we do our business, and had noticed a great improvement in his ability to track who's talking and when and all that. Secondly, I noticed the meeting was a lot smoother, even though there was a lot of complex issues being dealt with in a row. Productivity of how you guys dealt with machines, the meeting was excellent. I really want to thank you for all your efforts in participating in that. More importantly, we're seeing the fruit of that now. The meeting was, I thought, went really, really well. And the staff, I thought some of the adjustments made with the staff seems to be working extremely well in helping Sarah not be distracted by handout junk and stuff like that, or materials, I shouldn't say on the record. But I want to compliment all of you, and everybody, I think, has really been super good about that.
Thank you. Okay, we'll move on to item 22, testing reports. Questions? Need a motion to accept. Everybody clear with that? Moving on to item 23, Chief Inspector's Report. Any questions? There being none, we'll move on to item 24, comments by the general public. There is no general public. Okay, there's no comments by the general public.
Eric, I actually do have
Okay.
Mr. General, then to my understanding that now it appears that that there's an administrative policy to start examining the expired licenses. That you gave some leeway for folks, about 90 days or so, but now it seems pretty evident that the inspectors are not giving them warnings about their licenses anymore. So it kind of, we've gone through that little grace period, if you will.
We made our biggest issue was we hadn't properly noticed them, although we were legally competent because it was the way it's been in the legislature, the laws that were passed, etc. But I felt uncomfortable with the fact that we couldn't provide a logbook per se. So we had to do some of the work by the Legislative Council Bureau that was supposed to be done for us. It's posted, and we gave them a little bit of leeway to be sure we warned them right up front that we can't do especially the credo places. That's been a bigger issue because they're having to realize they have to deal with that. So the answer is we're starting to decide, and we're starting to work it hard.
Okay.
Yes.
I have a question. The schedule for testing, is this a new schedule? I had someone ask me when the new schedule was coming out, and I didn't know how to respond.
It's not a
Should we-
real, yeah, it's
schools
not a
have
real
this?
big deal for people outside the office because they can't get to that. When they come in, we schedule them for a test. It's not that they ask for a test on
Well, I had a
Saturday.
teacher ask me if the new
Yeah,
schedule.
we have a new
was
schedule,
published.
but it doesn't do them any good to know because they can't get to it without us scheduling when they come in with the application for testing.
Okay.
Then they're scheduled automatically. It's not, they should plan on those dates because they're not going to get them. It's first come, first served.
Okay.
First in the door gets the seat until they're filled. Some of the schools like to plan their attack, and we don't allow that.
You don't allow that anymore?
No.
Okay, we'll move on to item 25, comments by the board members and future agenda items.
I would like to comment that the letter that you sent out specifying every single thing that, what you can do, what you can't do, and about our continuing education. I had 3 phone calls, and I told all 3 of them, I said, did you read it? Did you read it slowly? Did you understand it? Because they're all screaming in my ear that they have to go back to school to get 900 hours instead of, and I'm like, no, that isn't what that said. Oh, yes, I read it, I know what it says. How can you do this? And I was like,
Yeah.
wait a minute. So no matter how you do it, which I thought the letter was great, I thought it was very self-explanatory. I wasn't confident.
We tried real hard to make sure, no matter how you read it, it came out the same result. But the people who are reading it real fast and they don't pay attention. So that's the problem. That's to be expected.
Anyone else? That brings us to item 26, which means we get to adjourn at 2:15.
Yay.
Yay!
It was a pleasure meeting all of you.
Anybody for shredding?
Yes. Want my shredding?
I don't know who the nice one was.
I'm going to give that back to you. I don't need that.
Okay, it's okay.